Maybe you're mad at state.
I
always say, if I don't catch you for one thing and I always react on another thing, it's for a reason.
It evens out the.
I'm gonna keep that. Yeah. It's
It's
interesting when you have kids that are like you can't punish them. What do you mean? Like, it is. Oh, I really excited. Exactly. I mean, you can disappoint.
Yeah. And when you say that, it does get there.
Right now, it is.
She just.
And real.
Yeah. That is hard.
Yeah. Yeah, when my daughter came.
At 4 in the morning.
20 minutes. Yeah, no, she came home actually at 1:30. Right. But the next day is now.
There's definitely
You know, I actually. And then it's always like, like. I would try to use sister who's like, I have her down, she was in her sister.
So you have to.
Oh,
Visit the children. Yeah. Okay.
I'll sit up.
That's right.
Myself, one of them, big mom, and I just think, oh. And she was nice. So I think, oh, okay. Not just I want to.
Yeah.
You have to give us some grace.
Yes.
We will have the state elections come to order. It is January 10 a.m.
Came with that.
Before we begin, just want to wish everybody Happy New Year. We're ready for 2026. Hopefully this next year. So, on. Okay. Will you stand? Actually, right? I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can you hear us all right in Springfield?
We
Yes.
can, yes.
Amy, roll call, please.
Ms. Bellercroft? Ms. Craig?
Present.
Ms. Genovese? Here. Ms. McCory?
Present.
Mr. Brett? Ms. Watson?
Present.
Vice Chair Turvin?
Present.
Chair Donahue?
Present. I would like to have a motion to recess the State Board of Elections and reconvene as the state officers electoral board.
So moved.
Second.
Been moved and seconded. Amy, roll call, please.
Ms. Bellercroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turvin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Marnie, if you would like to make a few comments and then we'll begin.
Absolutely. So I'd like to thank everyone for being here today. I'm Marnie Malowitz. I'm general counsel to the board. Today, the board is going to be hearing objections to the nomination papers of candidates seeking to appear on the general primary ballot 17th, 2026 as established party candidates. For each case called, I will read a brief summary of the objection, the recommendation of the hearing officer, and my recommendation on the disposition of the matter. Objectors will then have no more than 3 minutes to make oral arguments to the board, followed by candidates who will also have no more than 3 minutes. Staff will be using a stopwatch to ensure arguments stay within the time limit. The board may grant you more time for argument if they wish, but under Rule 11 of the Rules of Procedure, the board has the ultimate authority to decide what oral arguments may proceed. The board has 22 electoral board cases to hear today, including a motion to vacate a previous decision. The parties have already been given an opportunity to present evidence and arguments to the hearing officer. The board has copies of the objections, the dispositive motions and briefs, the hearing officer recommendations, and any exceptions to hearing officer recommendations to consider. So there's no need to reiterate every argument your side has advanced. Please also remember, no new evidence is to be presented here today. This is an opportunity to make legal arguments and explain your position to the board. Please keep your voice as loud as possible when speaking so the folks in Springfield can hear you. And also before speaking, for the benefit of our court reporter, please state and spell your name. Once the board has voted on your case, it will take several minutes for board staff to prepare and finalize your board order. You can pick up a copy of your board order in Chicago from legal counsel to Sean Sarku, who is over there in the corner. And in Springfield from our Deputy General Counsel, Jordan Andrew, who is hopefully waving at you right now. Once you have your order, if you have no other matters before the board, you are free to leave if you prefer. Thank you to the board staff and especially to the legal staff for all the effort you've put into our 80 electoral board matters this year. It's been a huge one. And with that, I'm ready to start calling the cases if you are, Madam Chair.
I think, is there anybody have anything else to say? Yeah, Marnie, proceed.
All right, well, first up, we have consideration of a motion to vacate dismissal for want of prosecution. This is agenda item 2A, Miller versus Brown, 25 SOEB GP 522. Is Mr. Winden here?
I am.
Great, thank you, sir. If you could stand by that little tattered piece of paper, that would be lovely. That's where the microphone is. I will read my recommendation and you'll have your opportunity to make your arguments to the board.
Thank you.
So at the December 9th SOEB meeting to rule on this particular case, objector failed to appear and the board dismissed the objection petition for want of prosecution, despite the hearing officer's recommendation to sustain the objection and remove candidate's name from the ballot. Counsel for objector Robert Winden filed petitioner's motion to vacate dismissal for want of prosecution on December 17th. The motion indicates Mr. Winden knew about the December 9th hearing, but attended other client hearings that day and did not learn of the dismissal of this matter until he received the decision by USPS mail. Now, as the board knows, the rules of procedure are strictly followed due to the tight timeline in which electoral board cases must be heard. Rule 3C of the rules of procedure caution that the failure of the objector to appear at the initial meeting of the board or at any subsequent meeting of the board or at any hearing before a duly appointed hearing officer without good cause shown will be sufficient grounds to default such objector, provided that the objector was served with the notice of the hearing. If an objector is defaulted, the objections may be stricken and dismissed. So case law instructs that the board lacks jurisdiction over this matter at this late date, as electoral boards do not have jurisdiction to reopen or modify their decisions. The case I'm citing to is called Caldwell, CALDWELL versus Nolan, NOLAN, and it is cited on page 6 of your packet. Section 10-10 of the election code requires that a copy of the electoral board's decision shall be served upon the parties to the proceedings in open proceedings before the electoral board. If a party does not appear for receipt of the decision shall be deemed to have been served on the absent party by personal delivery or deposit through the United States mail. That section further provides that upon the expiration of the date within which a proceeding for judicial review must be commenced under section 10-10.1, which is a 5-day period, the electoral board shall, unless a proceeding for judicial review has been commenced within such period, transmit by registered or certified mail a certified copy of its ruling, together with the original certificate of nomination or nomination papers or petitions and the original objector's petition to the officer or board with whom the certificate or nomination papers or petitions were on file, to the election authority to whom the ballot is certified, and to the appropriate county clerk, and such officer or board shall abide by and comply with the ruling. So here, if Mr. Winden had contacted someone to advise of his conflict on December 9th, we could have looked into rescheduling this case to be heard today or tomorrow, but he did not show up to prosecute his client's case. contrary to Rule of Procedure 3, and was not present to accept service of his client's board's order in person. So the statute required that the order be sent via US mail. At this point, candidate and presumably the election authorities believe candidate's name will appear on the ballot in March and will be certified to the ballot by the State Board of Elections tomorrow. I'm also mindful that the law favors ballot access. It is my recommendation under Caldwell, CALDWELL, that the board deny the motion to vacate for lack of jurisdiction.
Thank you, Mr. Wyndham.
Thank you very much. And appreciate council's response on this matter and research and information she's presented to the board. Where I disagree with council and believe the board does have the jurisdiction, does have the ability to hear this matter, is all of that case law, everything cited and discussed by the general counsel has to do with a final decision by this board. That is not what happened here. Illinois case law, and there's plenty of it, but case that I will cite, Flores versus Dugan, 435 Northeast 2nd, 480, stands for the proposition that a dismissal for want of prosecution is not a final and appealable order within Illinois case law. And therefore, it is my position that this board, one, has the ability to vacate the dismissal for want of prosecution, but also that this is the appropriate action. The section 10.1 of the election code that was cited by council that discusses judicial review talks about a party who is aggrieved by a decision of the electoral board, whereas that was not what happened here. Again, there's plenty of case law, Flores being one of the cases, that a dismissal for want of prosecution is not a decision on the merits of a case. It is simply a involuntary dismissal, and there are different avenues to remedy that. One would be refiling of a matter, which I'm not asking to do today. One would be to vacate that dismissal and to reinstate the case. So that is my position as to why the board has jurisdiction, has the right to hear this matter, and can, if it chooses, vacate the dismissal for want of prosecution. Now, as to why this board should do that and why the decision to the board's dismissal for want of prosecution, my opinion, was not appropriate on the last hearing date, was a couple things. First of all, as the hearing officer's recommendation laid out pretty clearly, this matter was consistently, in this matter, the hearing officer consistently bent the rules and did not strictly enforce the rules of this board to benefit the candidate. When the candidate missed deadline after deadline, the hearing officer went out of his way to give the candidate another chance to file something, to appear, to make his argument in front of the hearing officer. I understand the reasons that he did so, but for this board to then say, we're going to let all of those bending of the rules apply to the candidate, and then when we get to the decision date where the hearing officer recommended the candidate be struck, the candidate had 400 or more fewer signatures than required by law, and everybody had agreed at the last matter for the hearing officer that there was nothing to be debated. There was no contentious matter, and I don't believe the candidate had an attorney appear on that date. Obviously, it was not there.
3 minutes or up.
Can I have 30 seconds?
30 seconds.
Okay. Lastly, I think what is important to note is that the Rule 3 that the board used to dismiss for want of prosecution is not a required, it's not a shall dismiss. It is a may dismiss rule by the board. The board had the choice to say, hey, we're going to kick this over and we're going to contact Mr. Wyndham. And in that rule, it says if you are, miss a hearing without good cause shown, at that point, the board had no information. What the board should have done is continued it a month and said, Mr. Wyndham, appear and tell us what happened and why you were not there. Thank you.
You have a response or anything to say? Does anybody have any questions of Marnie or Mr. Wyndham?
I mean, to me, if we lack jurisdiction, we lack jurisdiction. 5 days after the opinion, this decision was certified to the election authorities. They're in possession of this opinion. And I think it's very unfair to candidate Brown at this point, the day before ballot certification, to tell him that the board no longer has a ruling on his case. and that he cannot be certified to the ballot tomorrow. Because under the Open Meetings Act, it is too late to put him on the agenda for tomorrow.
I tend to agree with that, but Marty, just a question on Flores, your response to Flores and it not being a final available order.
So I have not read Flores. This is the first time I'm hearing of the case, but was it within the electoral board context?
No, it was not. It was a circuit court case.
It was a circuit.
Absolutely, but and I recognize the rules are not exactly the same as what goes on in court and what goes on here, but Illinois civil procedure, like the rules of the process is followed within the electoral board outside of something to the contrary, a requirement to the contrary.
DWP has different impacts in different venues in different jurisdictions, and in our jurisdiction, in our venue, it had the impact that it did.
Do I have a
Well,
motion?
I,
Member Watson?
yeah, I'd like to know whether or not the administrative rules, say that this is not a final order in administrative laws.
So our rules of procedure do not say that. And as an administrative body, we are governed by, in this instance, what we are authorized to pass. What we are authorized to pass under Article 10 are rules of procedure. So I read to you Rule 3, which gives the board the right to default. And that's what was exercised here. And while the board may consider the rules of procedure, the Code of Civil Procedure, the board is not bound by it here. And I would suggest that electoral board cases, and in particularly our Rule of Procedure 3, is what governs here.
Thank you.
Make a motion to accept the recommendation of the general counsel and deny the motion to vacate the dismissal for want of prosecution.
There a second?
Second the motion.
It's been moved and seconded. Roll call, Amy?
Ms. Bellercroft? Ms. Bellercroft?
Yes.
Ms. Craig?
No.
I'm sorry, could you repeat that? Is that a no? We're having trouble hearing.
Yeah, I was just gonna ask that. Okay.
Okay, Ms. Craig?
She has tried to hand my.
Amy, I'm no.
Thank you. That's much better with the microphone. Ms. Genovese?
Yeah.
Ms. McCrory? Is that a yes? Mr. Brett?
No.
Could you repeat that?
Yes for McCrory, yes for Brett.
Thank you. Ms. Watson?
Present.
Vice Chair Turvin?
Yes.
Chair Donahue?
Yeah.
Motion passed.
Thank you for your time.
Thank you, Mr. Wyndham, very much. Marty?
Thank you. We will move into our cases to be ruled upon. The first is agenda item 3A, Durbin versus Moore, 25 SOEB GP 106. I will read my recommendation before I call up the parties. So this objection has two bases. First, the candidate failed to file the statutory minimum number of signatures. And second, the candidate, who is a candidate for governor, did not identify a lieutenant governor in his nomination papers. The objector in this matter is represented by attorney John Fogarty, and the candidate represented himself. The candidate filed a motion to dismiss, alleging he did in fact file a sufficient number of signatures and that he is not required to announce a lieutenant governor at the primary election stage. Objector responded that section 7-10 of the election code requires a joint petition for governor and lieutenant governor. The hearing officer recommends finding candidate not argued a proper basis to grant his motion to dismiss, and that candidate's nomination papers failed to comply with the statutory requirements of section 7-10A, which require a joint petition, including a candidate for governor and lieutenant governor, and a minimum of 5,000 signatures. And the record here reflects the candidate filed 3,297 signatures. The hearing officer recommends, and I agree, that the candidate's motion be denied, the objection be sustained, and candidate's name not be certified to the March 2026 general primary ballot as a Republican Party candidate for the office of governor.
Thank you, Marnie. Mr. Fogarty?
Thank you very much. Good morning. John Fogarty for the objectors. We ask that the recommendation be accepted.
Is there anyone here for Mr. Moore? All right, do I have a motion, please?
Make a motion to accept the recommendation of the general counsel and hearing officer. Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft? Ms. Ballard Croft?
Yes.
Ms. Cray?
Yes.
Mr. Navasi?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you.
Marnie, 3A2 or 3B.
Excellent. This next case, Hall versus Templeton, 25 SOEB GP 505. This is a records examination case with a Rule 9 hearing with objector represented by attorney Jeffrey Meyer. Following the conduct of the record exam, candidate was found to have 513 valid signatures, 13 more than the 500 required by Section 8-8 of the Election Code for offices in the General Assembly. The objector timely filed for a Rule 9 motion, and candidate filed a Rule 9 motion 1 day late. The hearing officer makes the following recommendations: that the Rule 9 filing delay was related to candidate's disability, and that it was for good cause, and the Rule 9 motion and evidence should be considered. That the objector proffered sufficient argument to strike one signature for missing an incomplete address, as both the address number and street name are required to evidence registration. The objector proffered sufficient Rule 9 evidence to strike two signatures, as those addresses were outside the district, denying the remainder of objector's Rule 9 motion for failure to meet the evidentiary burden. And also candidate proffered sufficient evidence to rehabilitate 10 signatures and did not proffer sufficient evidence to meet the evidentiary burden as to one other signature. The hearing officer recommends finding, and I agree, that candidate filed 520 valid signatures with her nomination papers, which is 20 over that required by Section 8-8 of the Election Code, to qualify her for placement on the ballot as a Republican Party candidate for the office of representative in the 94th Representative District of Illinois. With this proposed finding, the hearing officer recommends, and I agree, to overrule the objection and to certify candidate's name to the March 2026 general primary ballot. And is Mr. Meyer here?
Hi.
And we have a lovely white piece on the floor where you can stand for the microphone. Thank you.
Kind of you to mark that for me. Good morning, Jeffrey Meyer on behalf of the objector. I have just two very brief points. One, notwithstanding the disability, I recognize the application or the applicability of federal disability statute. However, in this case, the candidate did not file her request for an extension of time, make a request for an extension of time until after the time frame had expired. I believe it would have been appropriate for the request to have been made prior to the expiration of time. If she needed additional time, she can ask for that accommodation. But to belatedly allow it, I don't believe was appropriate. I believe that the candidate's belated request for an extension of time to file her Rule 9 motion, notwithstanding her disability, should have been denied. Secondly, the candidate's Rule 9 evidence that was presented here was not certified records from an election authority. It was, originally it was kind of excerpts from what they had used. They had taken the state board's own data, put it into a system for their use, and then backed it out of that system back to the format they received from the state board and relied on what was an electronic database record that they had received from the state board for use in collecting the signatures. It wasn't certified voter records from any election authority. I don't believe that it was appropriate. We did object to the hearing. I don't believe it was appropriate for that to have been considered as evidence. I recognize that notwithstanding either of those arguments, it still would have left the candidate above the statutory minimum based upon the evidentiary findings that were made. But I make those arguments for the record. Thank you.
Thank you, Mr. Meyer.
I will say that, Mr. Meyer, had you filed exceptions, those are some pretty concerning things you're raising to me. As you admit, It wouldn't have made a difference. The candidate would still be 10 signatures over, but in the future, give me an exception.
Well, thank you very much. Appreciate your time.
And is the candidate here?
Yes,
Thank-
I'm present. I'm
Um,
present, yes.
All right, Ms. Templeton?
Yes, I would like to thank you all for your time today, and after the favorable records review, as well as a favorable hearing officer recommendation, I believe I complied with good faith to the election laws, and I'm asking for you to certify me for the ballot for this year.
Thank you. Marty, anything else?
Mr. Meyer, are you okay with the board affirming on this basis, or would you rather I propose alternative rulings on the 10 signatures?
I believe that if the board's gonna make a decision, the decision should be made based on everything excluding the candidate's Rule 9 motion. That's what I would ask.
Okay, and what does the candidate say to that?
I say that even after, or even excluding my Rule 9 motion, I was still above the statutory limits for these signatures that we needed.
Okay, well, I agree, but under those circumstances, between the untimeliness of the request for extension and the fact that there were not certified records from the election authority used, I would recommend not considering the candidate's Rule 9 evidence, which would mean that the candidate is 10 signatures above the limit instead of 20 signatures above the limit.
Which still has the same result.
Which has the same result, the candidate would still be certified for the ballot.
I would rather you make a motion with accuracy for the record. So.
So here, the suggested motion would be that the candidate's motion to dismiss be denied. The objection be sustained, the candidate's name, oh, excuse me. Sorry, I was reading the wrong place, strike that and give me a moment, please. The recommendation is to overrule the objection, certify the candidate's name to the March 2026 general primary ballot, finding that the candidate has 10 signatures more than the statutory minimum of 500.
Do I have a motion?
So moved.
Second.
It's been moved and seconded. Roll call, Amy.
Ms. Miller Crowe?
Yes.
Ms. Gray?
We're having trouble hearing you now, Amy.
Ms. Gray?
Yes.
Thanks. Ms. Genovese?
Yeah.
Ms. McCory? Ms. McCory?
Yes.
Mr. Brett? Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turvin?
Yes.
Chair Donahue?
I am going to recuse myself on this issue.
Okay,
I,
motion.
yeah, and note that the people involved, so I'm recusing. Thank you very much. It's been ruled, it's been or moved and seconded and approved. Marnie?
Excellent. Moving on to the next case, agenda item 3C, Abbott versus Claiborne, 25 SOEB GP 507. I see we do have someone present on behalf of the objector, and it is again Mr. Meyer. So I will read my recommendation. This is an insufficient signatures case with candidate seeking placement for the office of U.S. Senator. Objector is represented by Attorney Meyer as well as Attorney Christine Svensson, SBENSON, who timely filed a motion for summary judgment relying on the staff count, which shows candidate filed 2,976 signatures within her nomination papers. Candidate alleged she did file signatures in excess of the statutory minimum of 5,000. However, at the hearing on this matter, the candidate failed to produce any evidence or testimony supporting her position that she had filed more signatures. On the evidence presented, the hearing officer recommends, and I concur, finding that the candidate filed 2,976 signatures within her nomination papers, which is 2,024 signatures below the statutory minimum of 5,000 required under section 7-10A of the election code. With this finding, the hearing officer recommends, and I agree, granting objectors' motion for summary judgment, sustaining the objection, and not certifying candidate to the March 2026 general primary ballot as a Republican Party candidate for the office of U.S. Senator.
Thank you, Marnie. Mr. Meyer?
Thank you. We concur, or agree with the recommendation of the hearing officer and general counsel and ask that you adopt.
Thank you. Is there any questions, any discussion? If not, do I have a motion?
I'll make a motion to adopt the recommendation of the general counsel and the hearing officer.
Do I have a second?
Second.
Amy, roll call, please.
Ms. Bella Croft?
Yeah.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Thank you.
Motion passes.
Marnie?
Excellent. Next case, Proctor versus Williams, 25 SOEB GP 514. And I will read my recommendation and then I will give the objector a moment to speak. Here, the objector objects to candidate's nomination papers with 3 allegations. First, that he filed an insufficient number of signatures. Second, that his nomination papers do not include a receipt for filing a statement of economic interest. And third, that the papers do not list his correct and current address of voter registration. Objector is represented by attorneys Stephen Bolton and Anthony Paraica, P-E-R-A-I-C-A, and we'll let Mr. Bolton introduce himself in a few moments. Candidate filed a motion to strike and dismiss objector's petition, alleging objector's interest is a false statement of material fact, questioning objector's motives for filing the objection, and that the objection he alleges is therefore improper under section 10-8, rendering the provisions of the election code governing ballot access and these proceedings to be unconstitutional. The objector filed a response citing to the 2011 Illinois Supreme Court case of Goodman versus Ward, Goodman versus W-A-R-D, which is cited on page 51 of your packet, to argue the board does not have the authority to disregard ballot eligibility requirements. The hearing officer recommends, and I agree, denying candidate's motion to strike and dismiss in reliance on Goodman, as candidate has failed to allege a basis to dismiss that this board may grant. The allegations that objector's interest in filing the objection as pled is sufficient under section 10-8, and any other motivation of the objector is irrelevant to these proceedings. As to the substance of the objection, the hearing officer recommends, and I agree, relying on the staff count, finding candidate filed 3,558 signatures with his nomination papers, which is 1,448 fewer than the statutory minimum of 5,000 required by section 7-10A of the election code. As the signature deficiency is dispositive of the objection and renders the statement of economic interest and address allegations moot. The hearing officer and I therefore recommend sustaining the objection, not certifying candidate's name to the general primary ballot as a Republican candidate for the office of Attorney General.
Thank you, Marnie. Mr. Bolton, I assume?
Yes.
Yes.
Morning, I'm Stephen Bolton,
If you could spell your name, sir.
Boulton, STEPHEN, if people don't get the first one wrong, they get the second one wrong. And if the board allows, I will simply adopt the recommendation of the hearing. Thank you.
Thank you. Is there anyone here on behalf of the candidate? Mr. Williams. All right, do I have a motion?
Make a motion to accept the recommendation of the general counsel and the hearing officer.
Second. It's been moved and seconded. Amy, roll call, please.
Ms. Bella Croft? Ms. Bella Croft?
Yes.
Ms. Cray?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Marnie?
Next case, agenda item 3E Carney versus Cowley, 25 SOEB GP 515. I see we have Mr. Erdman here on behalf of the candidate. Is anyone here on behalf of the objector, who is represented by Priscilla Centeno, CENTENO, and Ross Seckler, SECLER?
Is there anyone in Springfield, Amy?
No.
So in this instance, Mr. Erdman, we normally ask the candidate, would you prefer a ruling on the merits or would you prefer a one of prosecution?
Sorry.
Would you prefer a ruling on the merits or would you prefer a dismissal for one of prosecution?
Ruling on the merits is fine.
You step up, right, Chairman. Thank you. And
Good morning, my name is Scott D. Erdman, ERDMAN, on behalf of the candidate.
Excellent. So the objection is ultimately a records exam case, though objector also lodged circulator, notarization, and residency objections. Following the conduct of the record exam and without request for a Rule 9 hearing from either party, the candidate was found to have 833 valid signatures with her nomination papers. During the pendency of this matter, objectors did not proffer evidence or argument in support of their circulator, notary, page objections, or residency objections. The hearing officer then recommends, and I agree, relying on the results of the records exam to overrule the objection, finding specifically that candidates' nomination papers contain 833 signatures, which is 333 more than the statutory minimum of 500 signatures required under Section 8-8 of the Election Code. The hearing officer further recommends finding the circulator, notary, and residency objections fail for lack of proof. I agree with the hearing officer's recommendation to overrule the objection and certify candidate's name to the March 2026 general primary ballot as a Democratic Party candidate for the office of representative in the General Assembly for the 34th Representative District.
Thank you, Marty. Is there a discussion? Do I have a motion, please?
Oh, did Mr. Erdman have any?
Oh,
No.
no, sorry. I thought you said you were.
Take the
Okay.
yes and be quiet.
Yep.
take the win.
Do we have a motion, please?
Make a motion to accept the recommendation of the general counsel and the hearing officer on this matter.
Second. It's been moved and seconded. Amy, roll call, please.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion
Thank you.
passes.
All right, next, please, Marnie.
Next case, agenda item 3F, and hopefully council can help me pronounce his client's name correctly. Parent versus Solis, 25 SOEB GP 518. Mr. George, did you say Parent? Parent, okay, thank you. So the objector here is represented by attorney Michael Dorff. Alleged candidate's nomination papers failed to meet two requirements of section 7-10A. First, that the statement of candidacy is not notarized. And second, that following a records exam of individual signature line objections, the candidate failed to file the statutory minimum number of valid signatures. The objector filed a motion for summary judgment, arguing that the language of section 7-10 and the board's 2023 determination in the state officers electoral board case of Light versus Niemerg, that's LIGHT versus NIEMERG, number 23 SOEB GP 107, established that an unnotarized statement of candidacy is a fatal defect to a candidate's nomination papers. The hearing officer agrees that candidate's lack of a notarization on his statement of candidacy is a fatal defect of the whole of his nomination papers. Therefore, the hearing officer recommends, and I concur, that the objector's motion for summary judgment be granted. Additionally, as a records exam was conducted, the hearing officer further recommends relying on the results of the exam, finding candidate filed 797 valid signatures with his nomination papers, which is 85 fewer than the statutory minimum, 852, under section 7-10B of the Election Code. This is also a sufficient basis to sustain objector's objection, in addition to the notarization issue presented in the motion for summary judgment. So the recommendation here is to adopt the recommendations of the hearing officer and general counsel to grant objector's motion for summary judgment, sustain the objection, and not certify candidate's name to the general primary ballot as a representative in Congress of the 17th Congressional District, because candidates' nomination papers do not comply with the provisions of Section 7-10 of the Election Code.
Thank you, Marty. Mr. Dorf?
Morning, Madam Chair, members of the board. Michael Dorf, DORF, on behalf of the objector. We concur with the recommendation of the hearing officer and the general counsel.
Thank you, sir. Do I have a motion or is there discussion? Not motion, please?
Make a motion to accept the recommendation of the general counsel and hearing officer.
Second.
Been moved and seconded. Amy, roll call, please.
Ms. Beller Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you, Mr.
Dorf. All right, Marnie, please.
Next matter, 3F. Excuse me, just 3F. Moving to the next page, next matter, 3G, Dones and Sinkule, and I could probably use a correction on the pronunciation of that name as well, versus Pasheka, 25 SOEB GP 521. Here, the objector, who is represented by attorney Ed Mullen, objected to numerous signature lines and circulator notarization deficiencies on petition sheets within candidate's petition. Ultimately, the objector did not offer evidence or argument related to the sheet objections. The hearing officer recommends, and I agree, relying on the results of the record exam and finding candidate filed 724 valid signatures within his nomination papers, which is 151 below the statutory minimum of 875 signatures required under Section 7-10B of the Election Code for access to the ballot as a Democratic Party candidate for the office of representative in Congress for the 3rd Congressional District. On this finding, the hearing officer further recommends, and I concur, with sustaining the objection and not certifying the candidate's name to the March 2026 general primary ballot.
Thank you, Marnie. Is there discussion? Sorry, Mr. Mullen. Go ahead.
Good morning, thank you.
Yes.
As the general counsel has indicated, the candidate was found to be below the statutory minimum and did not file the Rule 9 motion. The candidate has sent an email to the board. I don't know if that has been made part of the record, and so I would like now, if possible, to respond to that so that, because I believe that's probably what the candidate is going to argue.
I will say that that document was not filed in the portal, so it was not provided to the board.
Okay, then I would suggest allowing the candidate to respond to the general counsel's recommendation, and if necessary, I will respond to anything that he says.
All right, so, please state your name and spell it for
My
the,
name is Mark John Pasheka, Senior. Last name spelled
speak up and speak to that green line.
MARKPASIEKA, Senior.
Perfect. Go ahead.
So I was notified about this objection by reading an article by Russell Lissau. I met Miss Marnie a day before I was supposed to do, I guess, a trip to Springfield to defend the shotgun blasting of my signatures. I mean, some of the elderly, their penmanship is bad. I know most of the people that signed my petitions. It's really disappointing that I'm not going to get an opportunity because I don't have the experience to do the legal defense of this. You know, I never figured out how to use the portal completely. Mr. Bry, beautiful person, he saw that I uploaded something. I think one of the ladies downstairs actually did that for me. She's like, you got to help me. You got to sign this and upload it. Everyone's been really helpful. I don't know if this is going to help me at all. You know, the objections are John Pacheca. My name is Mark John Pacheca. It's a technicality that they could probably amend with your blessing. All I can tell you is it's really sad that there's only one candidate when people go in and vote. And I still have neighbors dropping off petition sheets with signatures. People want choices. It's up to you. I mean,
It's not exactly that way, sir. As far as being able to waive statute and precedent, but Mr. Mullen, do you have anything to say?
Quickly, the candidate upload a standing objection to the portal for the records examination with the help of the board. He did not file a Rule 9 motion. Mr. Avila appeared on his behalf at the status conference after the time to file the Rule 9 motion had appeared. Mr. Bry gave him 24 hours to file a motion for good cause as to why he was not able to do that and give him an opportunity to do that. That was never filed. Mr. Bry gave him multiple opportunities to present his case and nothing. I mean, to this day, we don't have any evidence presented by the candidate to support his argument that he has enough signatures. So I believe that the general counsel's recommendation should be adopted.
Thank you. Is there any discussion? Questions?
I just wanted to say one thing. I appreciate your comment about people need choices. I agree with you 100%.
thank you.
But as you may or may not know, we are bound by statute, right? We have to follow rules. So if you have any objections to the rules that we need to follow, the place to take it is the legislature, which I'm sure you're trying to get there, but maybe someday. And next time, you know, pay a little bit more attention to the notices and things like that that are sent to you.
Yeah, my family, my wife comes first. I was having a lot of problems.
We know that, but those things have to be.
They have been valid before.
Yeah, well, you know, my wife actually collected all those signatures. I wish she was on board this time, but
So the point I wanted to make, and it's really for the benefit of everyone, you know, there are certain requirements of the election code that are subject to the doctrine of substantial compliance. However, in 2015, the Illinois Supreme Court, in the case of Jackson Hicks versus East St. Louis Board of Election Commissioners, the site to that case is 2015 IL 118929, came out and said that strict compliance is required. There is no substantial compliance for the signature requirements. So not only does the statute tell this board that they cannot allow someone on the ballot with insufficient signatures, but the Supreme Court has said it. So it unfortunately is just a requirement that the board must follow.
All right, thank you. Do I have a motion, please?
Have a motion, we follow the hearing officer and the general counsel's recommendation and adopt.
Thank you, member. Do we have a second? Second. It's been moved and seconded. Roll calling.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you both. All right. Marnie?
Great, thank you. The next case, agenda item 3H, Miller versus Moore, 25 SOEB GP 523. Let me make sure we have the correct Moore, because there are two Moores. Which Moore are you, sir?
Greg Moore, running for governor.
You're Greg Moore. This is Sydney. This is, okay, this case is for Sydney Moore, which is a different Moore. All right, Miller versus Moore. So this is a strict records exam case where neither party filed dispositive motions or a Rule 9 hearing. Objector is represented by Robert Winden and candidate by Max Solomon. The results of the record exam show candidate filed 1,191 valid signatures within her nomination papers, which is 212 above the statutory minimum, 979 under section 7-10B. The hearing officer recommends relying on the results of the records exam, overruling the objection, and certifying the candidate to the March 2026 general primary ballot as a Democratic Party candidate for representative in the Second Congressional District. I concur with the hearing officer in recommending to overrule the objection and specifically recommend finding candidate filed 212 signatures over the requirements of section 7.
Thank you, Marty. Mr. Wyndham?
Yes, Robert Wyndon, WINDON, on behalf of the objector, nothing further to add.
Mr. Solomon?
And good morning, Madam Chair,
Morning.
Board of Directors. My name is Max Solomon, SOLOMON, and I have no objection to the recommendation of the hearing officer and general counsel. Thank you.
Gotcha. Thank you both. Do I have a motion, please?
I move that we accept the recommendation of the hearing officer and general counsel.
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballarcroft.
Yeah.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett. Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passed.
All right, next, Marty?
Next case, agenda item 3I, Kitover versus LaHood, 25 SOEB GP 526. The next case is also filed by Mr. Kitover, who, according to my records, is not present. Is Mr. Kitover here or in Springfield?
Not in Springfield.
Mr. Fogarty is here on behalf of the candidate, and normally in these circumstances, we would ask you, Mr. Fogarty, would you prefer a dismissal for want of prosecution or a ruling on the merits?
Ruling on the merits, please.
I knew that.
What's your first vote?
So this pro se objector objected to candidates' nomination papers alleging candidate filed fewer than the statutory minimum number of signatures and objecting to quote nonconformity. Candidate represented by Attorney Fogarty filed a motion to strike, alleging objector lacks standing as he is not a resident of the 16th Congressional District, that objector failed to sufficiently state his interest in the objection, failed to state the relief requested of the electoral board, and failed to fully state the nature of his objection as required by section 10-8 of the election code. The objector also filed a document titled Motion to Strike, which argues that candidates' petition sheets did not use the forms on the SBE website, that the candidate collected insufficient signatures, and individual signatures and circulator information are defective. The objector reiterated these arguments in his response to the candidate's motion to strike. Here, the hearing officer recommends, and I agree, granting candidate's motion to strike, finding that objector's stated address is outside the 16th Congressional District where this race is, and as such, he lacks standing to file an objection under section 10-8, citing Lenahan, LENEHAN versus Township Officers Electoral Board of Schaumburg Township, which is cited on page 130 of your packet. Although the recommendation that the objector lacks standing is dispositive of this matter, the hearing officer also recommends finding the objection petition does not fully state the nature of the objections or identify the relief sought from the board, which are both elements required under section 10-8. So here, I agree with the hearing officer in denying objector's motion to strike as moot in light of the failure of the objection petition. And of course, granting candidate's motion to dismiss. Therefore, the recommendation is to dismiss the objection and to certify the name of candidate LaHood to the March 2026 general primary ballot.
Thank you, Marty. Mr. Fogarty?
We would agree with that recommendation and ask that you adopt. Thank you.
All right, any discussion? If not, motion, please.
A motion to adopt the recommendation of the general counsel and the hearing officer.
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballarcroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett. Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Marty?
Thank you. Next matter, 3J, Kitover versus Noli, 25 SOEB GP 527. Here the candidate is represented by Mr. Mullen. Mr. Mullen, would you prefer a ruling on the merits?
Yes.
Okay. So this objection filed by the same pro se objector as the last case, Objector Katover, reads in its entirety, quote, I object to candidate Paul Nolly's petitions in Illinois 16 on the grounds of non-conformity, unquote. Candidate filed a motion to dismiss objector's petition, alleging the objection petition does not state objector's interest, failed to state the relief requested from the electoral board, and failed to fully state the nature of the objection. In response, the objector presented arguments related to his stated residence address, which appears to be in the 5th congressional district, as opposed to the 16th congressional district, where the candidate is seeking office. The objector filed a motion to strike, identifying the bases for his nonconformity allegations. And in response, the candidate argued that objector's motion is an impermissible attempt to amend the objection petition. Here, the hearing officer recommends, and I concur, finding that the objector's stated address is within the 5th congressional district and therefore outside of the 16th congressional district. As candidate is not a qualified voter of the congressional district for which candidate is running, the hearing officer recommends, and I agree, that objector lacks standing to maintain this objection. The hearing officer further recommends finding the objection petition does not fully state the nature of objector's objection, which is a mandatory requirement under section 10-8 of the election code, granting candidate's motion to dismiss and dismissing the objection. Within the briefing related to candidate's motion to strike, the candidate requested that a records exam be held in this matter. The hearing officer and I will recommend denying the request for a records exam because the record is devoid of sufficient information to grant this request, as the objector did not object to any specific signature lines. So the staff, of course, would not know what to review in a records exam. So with these records exam recommendations, then the hearing officer and I recommend the candidate Nolly should be certified to the March 2026 general primary ballot.
Thank you, Mr. Mullen.
Nothing to add. Thank you.
Thank you. Discussion, questions? If not, motion please.
Make a motion to accept the recommendation of the general counsel and hearing officer.
Second the motion.
I'm sorry, I have one quick correction. Thank you to our deputy general counsel. It was the objector's motion to strike that requested a records exam.
Candidate
No, it
motion
wasn't.
to strike.
It was the candidate.
I was gonna
strike.
correct you, but it made sense.
Okay.
In context.
All right, well, there will be no records. That's the long story short.
Okay.
So.
All right, now do I have a motion?
And the corrected information to make accept the recommendation of the general counsel and the hearing officer on this matter.
Second, and when we are done, may I talk about one other provision of this hearing when we're done with the vote?
Amy, roll call, please.
Ms. Bella Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes. Member
Motion
Craig?
passed.
I just was reading in our report that a video was taken of this hearing and uploaded to social media. Is there anything we could do to prevent that in the future? I see nobody's consent was given.
No one's consent was given. Obviously, I was highly concerned by this, very upset by this.
Yes.
There was discussion as to whether there was someone to whom we could refer this matter. Unfortunately, though, and not that you can't refer the matter, you could refer the matter. However, our rules do not expressly state that our hearings cannot be filmed. So I think that in the future, we should add such a rule. I think that's a very great suggestion. As to the matter for referral, I don't know that recording a public hearing was a crime, but if board thinks it is, you could consider a state's attorney or attorney general for referral.
I don't think a referral's in order. I would just like to see it in our rules for next time, please.
I think that's a great idea. Thank you, Member Craig.
Yeah, I agree 100%. And I have another question. Does Mr. Kidover file a lot of objections?
He filed 2 this year and then he was also a candidate.
Gotcha. Just curious.
Mr. Merlin?
Where is it on social media?
I don't
It's
know.
on X.
What?
It's on X, on YouTube.
You wanna make sure you're gonna look okay in there? Make sure you look okay on the video?
Yeah.
Sure.
Yeah, I wanted to let you know, but I didn't want to have an expert communication, so I'm glad you're learning that now.
I believe it's just your voice.
Okay.
So, sorry.
It wasn't new. You gotta work. It's not the
Whatever.
first time.
But I think we need to clarify that, for the future. All right, Marnie, next.
Absolutely. So, agenda item 3L, Joggers versus Atkinson. In this records exam case.
No, I'm sorry, we need K.
We need K,
I'm
539.
sorry.
Yep.
Oh, I thought that, right?
25 SOEB GP 530. Do we have anyone here on behalf of the objector?
Here.
Okay. Our attorneys Adam Vaught or David Adelier present? Oh, yes.
Did we pronounce your name correctly?
Did
this
I do
time?
better? He's like, no.
Delia.
Adelia.
I-
I really have been working on it. I'm really, really sorry. I did try and listen to it on Google
Yeah.
and they got it wrong too. So I will read my recommendation. And if you both would like to come near this white piece of paper on the ground, the speaker will be right ahead of you and that way speak up so that Springfield can hear you.
Green line.
So here we have a record exam case. Neither party filed dispositive motions for a rule of the hearing. Following the conduct of the record exam, the candidate was found to have filed 796 valid signatures within his nomination papers, which is 204 below the statutory minimum of 1,000 signatures. The hearing officer recommends, and I agree, relying on the results of the records exam, and finding that the candidate filed 796 valid signatures, 204 fewer than the statutory minimum required for the office sought under section 8-8 of the election code. As such, the recommendation is to sustain the objection and not certify candidate to the March 2026 general primary ballot as a Democratic Party candidate for the office of Senator in the General Assembly for the 42nd Legislative District. And the objector can go first.
Thank you. Good morning. Thank you. Good morning. David Adelia for the objector. We agree with the hearing officer's recommendation. We ask the board to adopt.
State your name, spell it, sir.
Justin Brew, last name is Breaux. I don't object, but I would like to make a comment that as a first-time candidate, you know, you try to do well by your community and you try to figure out what issues are important to them and you try to get signatures that are associated with that purpose. But this is a whole different process. And I don't know if you can do anything about it. I just think that at least for first-time candidates or candidates that don't have representation, really doing something about finding a way to get the representation, because this is all over my head. I just don't know what's going on, and there are some motions I'm sure I could have filed, but I didn't understand what I could have done. So I'm not objecting to their objection, but I do think there's an issue where you have new candidates who want to be right by the community, but they get tripped up by some legal means. So that's my comment.
Well, Mr. Burrow, I commend you for attempting it this time around, and I encourage you to do it again. We need people
I definitely will run.
to run. So,
It's all on the website. It may be
And please say-
difficult to find some of the things, but you've got plenty of attorneys in here to say, how do I do it? Or you've got to ask for advice. Everybody does in this stuff, but I do encourage you to do it again.
and I think there are tutorials. Do you guys still do the online or no? No.
I can.
But it's difficult. and You're not the only one that
Let's
this
just
happens
candidate's
to.
guide that at least tells
Oh,
you
I
about.
read through it. It's just all the things.
Sure.
It is.
It's fair. There's a lot of legal
We've
requirements.
all been there, done that. Amy, we gotta have a motion first. Do I have a motion?
Make a motion to accept the recommendation of the general counsel and the hearing officer in this matter.
Second,
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese? Yes. Ms. McCrory? Yes. Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes. Thank
Motion
you.
passed.
Good luck. All right, next, Marty.
Next, we have agenda item 3L, Joggers versus Atkinson, 25 SOEB GP 538. In this records exam case, the objector is represented by Mr. Fogarty. And the objector alleges that accounting for the identified line objections, the candidate has not filed the statutory minimum number of signatures. The candidate filed a motion to dismiss objection for failure to file required appearance, defective appearance, and failure to appeal, or to appear, excuse me. The motion alleges objector's counsel partially completed appearance form in this case was insufficient under Rule 3 of the board's rule of procedure to allow him to represent objector in these proceedings. And he argues that in filing a defective appearance, Mr. Fogarty was not properly appearing on behalf of objector, and that objector did not appear before the hearing officer during the pendency of the matter. And therefore, this case may be dismissed. The hearing officer recommends denying the motion to dismiss because of the rules of procedure do not provide a penalty for filing only a partially completed appearance form. Counsel did appear and was available for every status conference and hearing on all stages of this proceeding. His full name and contact information were available through the petition and objection portal, and candidate did not allege any form of prejudice resulting from the partially completed appearance form. Hearing officer recommends relying on the results of the record exam, which found that candidates' petition sheets contain 881 valid signatures, which is 119 fewer than the statutory minimum of 1,000 under section 8-8 to sustain the objection and not to certify the candidate to the March 2026 general primary ballot. Now, candidate filed an exception to the hearing officer's recommendations, restating the arguments made in the motion to dismiss, and also alleging that the board lacks jurisdiction as a result of the incomplete appearance form and objector's failure to personally appear before the board. My recommendation is that the arguments fail because the board has jurisdiction over this matter under sections 10-9 through 10-10 of the election code. The objector's counsel appeared on objector's behalf in this proceeding as authorized by Rule of Procedure 3A. Objector's counsel has been present at all hearings in this matter, and objector is therefore not in default under Rule of Procedure 3C. Rule 3C provides that the failure of the objector to appear at the initial meeting of the board or at any subsequent meeting of the board or at any hearing before a duly appointed hearing officer without good cause shown shall be sufficient grounds to default such objector, provided the objector was served with notice of the hearing. And again, Mr. Fogarty appeared at every meeting. Therefore, I concur with the hearing officer's recommendation to deny candidate's motion to dismiss, to find the candidate filed an insufficient number of signatures, to sustain the objection, and not to certify the candidate to the March 2026 general primary ballot.
Mr. Fogarty, you have anything to add?
I don't. The candidate is in Springfield though, and given the posture, he could go first.
All right. Mr. Atkinson, please.
Hi there. Good morning, ma'am. Board, thank you for having me here this morning. Wish it was under different circumstances, but it is what it is. I want to talk about a couple things here because this is what I wanted to do today, and I chose not to do it because I read a little disclaimer on the bottom of the paper, that appearance form. This is what this is about for me. And for the board, for the people of Illinois, is who do the rules apply to? Already this morning, since I've been here, I've heard, I believe it's the attorney, I'm sorry, I couldn't see the TV from where I was sitting, multiple times. These are our rules of procedure. that has come, that we've all heard it multiple times, and I guess now somebody's videotaping and putting it out there so everybody gets to hear that. You guys are standing behind these rules. Then we're talking, the board is talking to another candidate, and I believe it was the general counsel again. We have to follow the rules. That's what was said to a candidate who ended up being thrown off. We have to follow the rules. It doesn't matter. We have to follow. You don't get to have discretion over what you follow and what you don't, because that's why you have the rules. Then lastly, it was when you found out that somebody was recording something, I don't know if it was here or there, but somebody, you know, asked, can we fix the rules for next time? So you found a problem with the rules, or a perceived problem with the rules, and so you're choosing to, let's address that. Let's try to get that fixed for next time. I'm saying that just because that is how important that you guys have all made it very clear how important these rules are. So what I wanted to do was come today. I brought a friend with me, Miss Cook, and I wanted to fill out an appearance form. And I just wanted to write her name across the top of it and hand it to you and see if you would allow her to represent me. We all know the answer to that. The answer would be no. You don't know who she is. Just like I don't know who Mr. Fogarty is. Well, I do now. And that's all he did. He wrote his name across the top of a piece of paper. I put it in the evidence or uploaded it to the link and all that kind of stuff. So I hope you guys saw all that stuff. But that's all he did. He was so entitled, he did not have to put the required information, which says a party must file with the board a written appearance. A party. That is not Mr. Fogarty. That is the candidate or the objector. A party must file with the board a written appearance stating their name, address. He put his last name. He did not put his address. Excuse me. A cell phone number. There was no cell phone number. So I don't know how my hearing officer had his phone number, because there was no phone number listed. So that doesn't make any sense. And I know a lot of people, and you guys are going to hear it today and tomorrow, are playing the first time candidate card. I get it, and that's got to be annoying, and we're trying to be very sympathetic. I get that. I'm not playing that card. I can read. You know, I'm not arguing on whether or not, you know, 20 people were actually registered to vote or not. If I sat here, I came down here that day and saw what I get hit on. I'm not arguing that. What I'm arguing is the fact that we shouldn't have even gotten to that point, because one of the very first rules of your procedures was broken. It was broken. Had I not shown up to, I don't know the date, so forgive me, to that first meeting, right? It would have been most likely.
Bring your
I'm sorry?
Bring your remarks to a close.
Yes, ma'am. Sorry. I would have been knocked off because I would have broken one of those very first rules. Mr. Jokers broke one of the first rules. And the last thing I'm going to say, ma'am, is I don't know if I'll take the blame for it, General Counsel. I don't think I was arguing the board's jurisdiction. I think the point I was trying to make in there was Mr. Fogarty's jurisdiction. I don't see how Mr. Fogarty is allowed to stand there in front of us today, because he has not been done the proper steps to be counsel for the objector. So what is he doing there?
Thank you. Mr. Fogarty?
Yes, thank you very much.
Speak up for me.
Yeah, thank you. I have been before you and before the hearing officer, sitting next to Mr. Atkinson, present for every step of this way. And I think where Mr. Atkinson is going is arguing that the rules of procedure are the same as statute. They are not. Rules of procedure are set up so that we can orderly make these cases go. You've got a lot of them before you. Mr. Atkinson had no problem contacting me at any time, even as a result of my abbreviated, hastily filed appearance. At any rate, at the bottom line is Mr. Atkinson doesn't have enough valid petition signatures. That's it. Anything else is a sideshow, and I ask that you accept the recommendation of the general counsel and the hearing officer.
Discussion, questions?
I just have one comment. Mr. Atkinson, I will mirror Mr. Fogarty's comment to you. There are difference between the rules of procedure and the statute. The rules of procedure, we have a little bit more discretion on. statutory laws, we do not. So that's where our hands are tied. So I think it was my comment that you're responding to. Let me just clarify that for you. Secondly, if you do have a problem with the fact that our hands are tied by the statute, you need to go to the legislature with that. I appreciate your comments and I feel frustrated pretty much every single meeting that our hands are tied, but they are. So again, rules of procedure, we have more discretion. Statute, we do not, just to clarify.
No, I'm not faulting anybody for having their hands tied. I get that. But what I'm noticing here, and it seems to be consistent, at least with this hearing officer, and I haven't seen the general counsel's recommendation for tomorrow on certain cases, that your hands quickly become untied for what we're seeing is it's a pattern of the incumbent. Your hands are untied because Mr. Fogarty did not, or Mr. Jogers did not file a completed appearance form.
If you're an incumbent or not an incumbent. You're not going on.
I'm just stating this is the pattern that we're seeing. It's whether it's true or not, that is the pattern. But your hands are untied because for Mr. Jogers, who did not file a completed, per your rules, a completed appearance form.
We are done now. You have had your say and we have made our comments. We are now going to rule on this matter.
I need a motion.
I need a motion.
I make a motion that we adopt the recommendations of our general counsel in hearings.
Do I have a second?
Second.
Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms. Craig,
Yes, Amy, we're having a hard time.
yes,
Okay, that's why. Good.
Ms. McCory,
We're barely hearing you, Amy, but yes.
Mr. Brett, Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passed.
Well, thank you for coming here today.
Thanks, Marty.
Okay. Thank you.
Thank you. The next case, agenda item 3M, Jarek and Johnson versus Marceline, 25 SOEB GP 539. This is another records exam case. The objectors are represented by Mr. Fogarty, and they allege that the candidate, who's represented by Mr. Mullen, has filed an insufficient number of signatures under section 8-8 of the election code when individual line objections are accounted for. Neither party filed a dispositive motion, and candidate did file a timely Rule 9 motion, but it was withdrawn. The hearing officer recommends, and I agree, relying on the results of the records examination, which found that the candidate's nomination papers included 1,041 valid signatures, which is 41 above the statutory minimum, 1,000 required under section 8-8. As candidates' petition sheets contain more than the statutory minimum number of signatures, the hearing officer recommends, and I agree, overruling the objection and certifying candidate's name to the March 2026 general primary ballot as a Democratic Party candidate for the office of Senator in the General Assembly for the 38th Legislative District.
Thank you, Marty. Mr. Fogarty, any comments?
We accept our fate.
All right, Mr. Mullen. Thank you. All right, do I have a motion?
Motion to accept the recommendation of the hearing officer and the general counsel.
Have a second?
Second.
Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett, Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right, next up, Marty.
Next up, agenda item 3N, Eyeshide and Husley versus Edwardson, 25 SOEB GP 542. This is also a records exam case. The objectors in this matter are represented by John Fogarty. The candidate did not file an appearance or participate in these proceedings. However, service of the notice of candidate via registered mail was delivered on November 25th. The hearing officer also documented that he sent candidate letter via US mail and did not receive a response. So we know that the candidate is aware of these proceedings. A records examination was conducted on December 2nd. The hearing officer recommends, and I agree, relying on the results of the hearing exam, which show candidates' nomination papers include 428 valid signatures, which is 72 below the statutory minimum of 500 signatures required under Section 8-8 of the Election Code. Accordingly, the hearing officer recommends, and I agree, sustaining the objection and not certifying candidate to the March 2026 general primary ballot as a Republican Party candidate for representative in the 90th representative district because candidates' nomination papers do not meet signature requirements.
Thank you, Marty. Mr. Fogarty?
We agree with that recommendation and ask that you adopt.
Discussion? Not. Motion, please.
Richard.
Yeah, I said motion.
Motion to accept the recommendation of the general counsel and the hearing officer.
Second?
Second the motion.
All right, it's been moved and seconded. Amy, roll call, please.
Ms. Fowler Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Madam Chair, if I could have 2 minutes to grab a bottle of water,
Yes,
thank you.
you may. I'll take this a little hiatus here. You have 3 minutes, and if you would like to stand on the little white piece of paper and speak to that green light.
We're
um,
muted, we're muted.
Right up there on the ceiling, and then the people on the camera can hear you.
And if I can just announce quickly, Mr. Moore was the candidate. I'm not sure where that noise is coming from. There we go.
I just stay like this the whole time.
Mr. Moore is the candidate in Durbin versus Moore. The
Wait.
objection.
Whoa, 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 whoa.
We on 543?
That's what I have, but that's not what I heard.
We are calling a case that was called at the very beginning because Mr. Moore has appeared. So it's one of the earlier cases and we're just giving him an opportunity to speak.
Okay.
3A.
3A, Durbin versus Moore. And Mr. Fogarty is also here on behalf of the objector. We're not, planning to revote on the case, but giving Mr. Moore a moment to have his words.
Either that or he waits until the very end, and I think it's only fair. So you have 3 minutes, Mr. Moore, please.
Please, before the 3 minutes, I want to thank you for allowing me to come in very late. Whatever my reason, I'm so sorry. 3 minutes now. Sometime last year, my initial Google search on the internet for a specific course, the commencement date for the signature gathering, and the submission period to the Board of Elections yielded far more results. I also found a question answered that I did not ask, but very relevant, which is getting on the ballot. How many signatures does it take? We stated 25,000, 8,240, 3,240 for independent Democrats and Republicans, respectively. A recurring feature of the exercise was incessant harassment by officers of the CPD on trained platform that charged me to hearing on multiple occasions. But after the very first hearing, which I moved to the district court for review, no judge wanted to hear my case anymore. So the state attorneys moved a motion that the case be dismissed, that they were not willing to prosecute charges against me anymore. I mean, after the very first, which I had already taken to the circuit court for administrative review. At the same time, those legal luminaries also advised me not to solicit for endorsement on the trains. Interrogation by the officers of the CPD and going to administrative hearing adversely encroached on my time, but I succeeded in obtaining the above minimum required signature for a Republican gubernatorial candidate to be on the ballot, the primary ballot, even though I strongly feel it is the lieutenant governor of the party nominee that matters. And this ought to be selected after the primaries. I have also complied as our law requires. I therefore plead before this most esteemed body to retain yours truly on the March 17th Republican ballot, primary ballot, and let the people decide if Moore should be Illinois' next governor or not. Actually, I have a lieutenant governor. We went to the index office in Springfield. They said another form will be printed next year. I said, I'm submitting it this year. I went to your office. I just saw a notice on the door about this meeting. Everything you asked me to do, I've done. Apart from the 5,000, there's the issue of 1% signature. And what I got was that 25,000 standard for independent candidate, which I've run before, 8,000 plus for Democratic candidate, and then 3,000 plus for Republican, which I am one. So I've done everything. I sent it to the officers concerned. I sent my lieutenant governor the receipt from the index office and everything. Please let me be on the ballot. Let the state, the people decide if I should win or not.
I'm afraid that we've already ruled and we can't go back. So, no,
What do I do now?
Run next year. and
Yeah.
Get enough signatures.
Get enough signatures and run in the next election.
Signatures. I have.
You
Sir,
don't.
You have less than 5,000, which is the required amount.
No, it's not 5,000, it's 5,000 or 1% of the last vote cast. I didn't make the law. You people made the law, or the legislature made the law.
Yeah.
It's not absolutely 5,000, it's 5,000 or 1%. The requirement for Democrats to be on the ballot is 8,240. For Republican, I sent everything to you and you saw what I sent. I didn't formulate it. I didn't formulate anything. I'm trying to comply. 4 years ago, I came to Springfield. I didn't come with my car. I couldn't get to you. I said I went to the post office to mail. You sent back my what do you call it? My petitions. This year I had to drive to Springfield easily. And I submitted
Appreciate
everything.
your argument, sir, but we've already ruled on the case. And it's a final order. So all I can do is encourage you to educate yourself on the election rules for the next election cycle and file your petitions again. And hopefully you will be successful next time. Right,
And
thank
your,
you.
your board order is available from Mr. Sarku back there in the
In the
corner,
back.
if you haven't received it yet.
Oh,
He has a written order.
he already has.
Oh, he has it. Okay. Excellent.
All right. We've given you,
I'm sorry. I have a copy for everybody. I'm so sorry. I'm very sorry.
Okay, sir, whatever was submitted during the hearing is all we can look at right now. So if you can take that back.
there is comment. What do you think about it?
It's just his.
Thank you very much, Mr. Moore, and we've given you a little exception here. And we will continue. Marnie?
Moving into the
Hang
next
on.
case, agenda item 2O. Mr. Fogarty, how do I pronounce your client's name?
Cianci and Africano.
Okay, Cianci and Africano versus Ellington Snipes, 25 SOEB VP 543. This is another records exam case. Objectors Cianci and Africano, represented by Mr. Fogarty, filed an objection to the nomination papers of Robert Ellington Snipes, a Democratic candidate for the office of Representative in the General Assembly for the 79th Representative District. The objection petition alleges individual line objections, resulting in insufficient signatures. The candidate filed a motion to strike and dismiss objector's petition on numerous bases to the sufficiency of the objection petition based on objector's partisan affiliation, the appearance of unchecked page objections within the recapitulation sheets, alleging the petition lacks good faith and reasonable inquiry, alleging an impermissible motivation for filing the objection petition, and alleging the state officer's electoral board did not convene within the timeline required under section 10-10 of the election code. In their response to the motion, objectors argue that candidates' motions allegations are legally irrelevant, as section 10-8 does not require an objector to have a particular party affiliation. The objection petition only objects to individual signature lines of candidates' petition sheets. The candidate's reasonable inquiry allegation fails because the majority of objectors' line objections were sustained, and objectors' motivations are irrelevant and fail as a basis to strike or dismiss, citing to the case of Havens versus Miller, HAVENS versus Miller, cited on page 211 of your packet, which holding that an objector's motivation is legally irrelevant to the substance and validity of the objection. Also citing to Nader, NADER, versus Illinois State Board of Elections, also cited on page 211, holding an electoral board is not authorized or empowered to investigate the compilation or motivation of an objection petition. Finally, objectors cite to Shipley, CHIPLEY, versus Stevenson City Electoral Board, also cited on page 211, holding that the section 10-10 mailing timeline is directory and candidate was aware of the SOEB proceedings as early as November 19th. As to candidate's motion to strike and dismiss, the hearing officer recommends denying the motion in reliance on the cases and arguments cited by objectors in their response. And as to the substance of the objection, the hearing officer recommends relying on the results of the record exam, finding candidates' nomination papers contain 452 valid signatures, which is 48 below the statutory minimum of 500 required for placement on the ballot as a Democratic Party candidate for the office of representative in the General Assembly. Accordingly, the hearing officer recommends, and I agree, that objector's objection petition be sustained, that candidate not be certified to the March primary ballot. And I agree with the hearing officer recommendations as the candidate filed insufficient signatures under section 8-8 of the election code.
I assume I know what you're going to say. Would you please state your name and spell it, please?
I'm Robbie Ellington Snipes, ELLINGTON-SNIPS, like Duke Ellington and Wesley Snipes.
Do you have any comments, Mr. Snipes?
I was going to let the objector go first, and then I was going to respond there.
All right.
Thank you.
John?
We would agree with the recommendation of the hearing officer and the general counsel and ask that you adopt it.
Thank you. Mr. Ellington Snipes?
I'm going to, again, we'll state just from the record because there's some things that are disturbing. I heard the gentleman this morning speak with the Fogarty, and it's interesting that the hearing officer did not bring that up because that was in my motion. The fact is, under 3C, and also to even give it more validity, is Supreme Court Rule 13. When it comes to a veteran, doesn't say whether you're a veteran or not, but the individual is a veteran. You just can't put Fogarty, because when I ran Fogarty up under ADOC, which allows you to look up under who our attorneys are, you find out that there's a lot of Fogartys, but there's 2 John Fogartys as far as that's concerned. So when you just put Fogarty up on there, that can be somewhat misleading. The other thing is your rules specifically state, and I just haven't looked at the paper, so therefore what's saying is if we're going to follow a process, why not just say that there'll be exceptions, because it tells you that you have to not only put your name and your name, your address, his full name and his full address as far as that's concerned. That again wasn't done. And so I didn't find this out until December 4th. They alleged on the 19th that I knew. No, I didn't. What I did was I received the email late, not the email, excuse me, the notice. They had already had the hearing. It came to me and I got it on 11/18/25. So I called or whatever the State Board of Elections, who told me that it was assigned to a Ms. Crane and gave me that number. And then I told them that I had a motion, because now I needed to kind of read through this information that she gave me. And I immediately filed a motion to dismiss, basically because the objectors have never showed up in this hearing, period. If you look at it, they never showed up for one, not the initial or thereafter. Yes, they had an attorney, but the attorney, again, just saying with the name Fogarty, is, again, that's kind of like, you know, if you were to follow Supreme Court Rule 13, that would kick you out of court. Matter of fact, it does state up on Supreme Court Rule 13, which any lawyer is familiarized with, that there's sanctions that goes with that as far as that's concerned. So I don't understand when they say that there are no sanctions. Going through my process, my other note, but it basically, it identifies sanctions up on the Supreme Court Rule 13, but it's easily accessible because just go to the Supreme Court Rule site. The other thing is I didn't have notice, didn't have it on the 18th, and I certainly did not have it when they had the hearing. The hearing the records examination. The only way I found out was on December 2nd that all this had basically been done. They told me to go into a portal, try to go into the portal. It didn't allow me. It says forbidden access. So I had to call the State Board of Elections back or whatever. But after them, it still stays forbidden. But they download it because it's a glitch in the system. So what I'm saying is there was still like a notice up under what I consider to be the 14th Amendment of the Constitution that allows me due process. Because to say that I had that information, if you look in the record and look at Mrs. Crane's hearing summation on nothing in there says that it notified the candidate, nothing in there basically stated anything about a hearing being conducted.
Thank you, Mr. Ellington Snipes. You have your 3 minutes.
And may I?
Mr.
I have,
Fogarty,
2 minutes, 50 seconds. I'll be much less than that.
please.
All my information on every case that I set before you on is in the portal. I'm easily found. Because we have the portal, there is no question that someone needs to file something directly and give notice to the opposing party. It's a non-issue now. And so you've spoken to it in a prior case. You should speak to it again. And then Mr. Ellington Snipes was emailed at some point prior to the records exam occurring by Hearing Officer Crane, pointing him to the portal, what you need to be doing, and the date for the next hearing. And I get it, the portal is not the easiest, but it was all there, and in our view, appropriate notice was given. And I think it does bear saying, when you are a candidate, you have to be extra attentive to proceedings that may be taken against you. So I'll leave it at that.
Thank you, Mr. Fogarty. The bottom line here is there are not enough signatures, and that is an absolute. That isn't anything we can, it's an absolute.
Yeah, I could say this, whatever it can be, because it's going to in court. It's an absolute. If you looked at that, if I was able to come there, you have an individual that is the Michael Cobb. He's over the Democratic Central Committee. They challenged his signature and said that it wasn't correct. He couldn't be there. He's also an alderman, Lenore Noble. So what I'm saying is, if I had been there and got the record, then yes. But even though he states it on the 19th, this was after the fact, and again, it did not allude me of anything on the 20th as far as that's concerned. So
all right,
to say that we had anything before December 4th is a misrepresentation of the truth here.
All right. Do we have discussion? Any questions from Springfield? Any questions here? Marnie, any comment?
I could just mention that the board is required by statute to send notice of these proceedings via certified mail. And over the years, certified mail has gotten slower and slower and slower. So it's unfortunate. My thought would be someone talk to the legislature and tell them that we should serve process by some other method, because it's slow. That's sort of my thought on that issue. It's unfortunate.
All right. Do I have a motion?
Make a motion to accept the recommendation of the general counsel and the hearing officer on this matter.
A second?
Second.
Been moved and seconded. Amy, roll call, please.
Ms. Bellar-Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Frett, Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Marnie, next up, please.
Next case, agenda item 2P, Oriyama, Hines, and Bayless versus Duzer. 25 SOEB GP 540. Objectors, who are represented by Attorney John Fogarty, filed an objection to the nominating petitions of August Duzer, who is represented by Attorney Max Solomon. The candidate seeks placement on the ballot as a Republican Party candidate for the office of representative in the General Assembly for the 37th Representative District. The objection petition alleges individual signature line objections and page objections regarding circulator affidavit deficiencies. No party filed dispositive motions or Rule 9 motions in this case. Following the conduct of the records exam, candidates' nomination papers were found to have 441 valid signatures, which is 59 below the statutory minimum of 500 signatures required by Section 8-8. Accordingly, the hearing officer recommends that the board sustain the objection and not certify the candidate for ballot placement on the March 17th, 2026 general primary ballot. I agree with the hearing officer's recommendation and also recommend finding objectors' page objections have been rendered moot as candidates' signature deficiencies are dispositive of this matter.
Thank you. So, John, should I go to Mr. Solomon, or do you have a comment?
We ask that you accept the recommendation of the hearing officer.
Mr. Solomon, please.
Thank you, Council. Thank you, Madam Chair. Morning again, Board. On behalf of the candidate, we accept the recommendation of the hearing officer and General Counsel.
Thank you. Thank you both. Do I have a motion, please?
Motion to accept the recommendation of the hearing officer and the general counsel.
Second?
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms.
Yes.
Craig, Ms. Genovese, Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue. Motion passes.
Thank you, Amy. Next up, Marty.
Next case is 2Q Bell and Bell versus Carter, 25 SOEB GP 545. And I understand that Carter is present. Excellent. So I'll read my recommendation and then the parties can comment. So this is another records exam case with objectors Bell and Bell, represented by Attorney Fogarty, objected to the nomination papers of candidate Carter. Objectors alleged candidates' nomination papers contain an insufficient number of signatures on their face and also make 44 individual line objections within the petition sheets. Objectors also allege that candidate failed to file a receipt for filing a statement of economic interest. Prior to the conduct of the records exam, a staff count was conducted in this matter and found that candidates' petition sheets contained 497 signatures out of a required 500 signatures. So here the candidate filed a motion for summary judgment, incorporating the staff count showing 497 signatures, 3 fewer than the statutory minimum of 500 required under section 8-8 of the election code. And candidate argues that the signature threshold is mandatory and absolute, citing to Jackson Hicks, JACKSON/Hicks versus East St. Louis Board of Election Commissioners. It's cited on page 254 of your packet. I also mentioned it in connection with an earlier case. So in response, the candidate disputes the staff count and states that the petition sheets contain exactly 500 signatures. A records exam was held because the numbers were very close. So during the records exam, 32 of the 44 line objections were sustained, resulting in 465 valid signatures within candidates' nomination papers, which is 35 signatures below the statutory minimum. There was no Rule 9 hearing requested. The hearing officer recommends, and I agree, granting objectors' motion for summary judgment, as no genuine issue of material fact exists as to candidate having submitted an insufficient number of signatures. The recommendation is that the objection be sustained and candidate not be certified to the March 2026 general primary ballot as the Democratic Party candidate for the office of representative in the General Assembly for the 93rd Representative District.
Thank you, Marty. Mr. Fogarty?
For the objectors, and we would ask that that recommendation be adopted. Thank you.
Ms. Carter?
Yes. So first off, I want to say thank you all for everything you guys do. I'm not an attorney, so I'm not going to have all this fancy speak. I came up here from Central Illinois because I felt very strongly in this. First off, with the statement of economic interest, that was filed about an hour and a half to 2 hours after I filed all my other paperwork, because I had to wait for the Secretary of State to come. So I did actually have that filled out, and that has actually been submitted. So that part there should be wiped out. With the signatures, I did have the exact 500. Now that I don't know where the count came from. Every time I count through that, I do show 500 signatures. On top of that, the 35 that were marked as not correct. Unfortunately, I did not have the time to do so, but I was actually working on affidavits for all of those people because I know every single person. Myself, because I am not wealthy, I went to every single person and I got every single signature. Those signatures were valid. Unfortunately, I didn't have the time to get to every single person to get those affidavits filled out. But I am 100% sure that those signatures are valid and that I had the minimum of 500 signatures. Other than that, that's all I have to say.
Thank you. We appreciate that, Ms. Carter, but discussion?
On the statement of economic interest issue, I believe the objector abandoned that claim.
Okay,
So
we
if
did.
you'd like to have something in the order that says that issue is moot,
I would love,
then if Sean doesn't mind adding that into the order,
Yes.
that would be wonderful.
thank you.
All right, so do we have a motion?
I make a motion to accept the recommendation of the general counsel and the hearing officer and encourage you to try this again next year or the year after that, whatever the next cycle is. Second.
Been moved and seconded. Roll call, please, Amy.
Ms. Bellicroft,
Yes. Yes.
Ms. Craig,
Yes.
Ms. Genovese? Yes. Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Thank you.
Thank you.
Ms. Watson,
Member
She said if she stepped away, I had her proxy, so yes.
okay. Vice Chair Turbin,
Yes.
Chair Donahue,
Yes.
motion passes.
Barney, next up, please.
Excellent. And next case, agenda item 2R, Gordon and Mock versus Cowley, 25 SOEB GP 567. Is Mr. Finko here on behalf of the objectors? He is not. Mr. Erdman is here on behalf of the candidates. So, Mr. Erdman, on these circumstances, would you prefer a ruling on the merits or would you prefer a dismissal for want of prosecution? Okay, excellent.
I was hoping to be able to wish you good morning and good afternoon. Just missed it by a few minutes.
So you can do it at the other.
I can speak slowly. It would help. So this is a records exam case in which objectors Gordon and Mock, represented by attorney Andrew Finko, filed an objection to the nomination papers of candidate Cowley. Objector's petition alleges 4 bases for disqualification. First, that individual line objections subject to a records exam, that circulator and notary deficiencies take out full petition sheets, that the petition sheets contain more than the maximum number of signatures, and that candidate does not reside at the address listed on the statement of candidacy. Candidate filed a motion to strike and dismiss portions or all of objector's petition, moving specifically to strike paragraphs 10, 12, and 13 for failure to fully state the nature of the objections within, all related to the alleged circulator misconduct, and to strike paragraph 17, which alleges that candidate filed more than the maximum number of signatures, as she filed only 1,290 signatures, fewer than the statutory maximum of 1,500 signatures under section 8-8 of the code. Objectors responded that candidate is sufficiently on notice of their objections and that an electoral board cannot close its eyes and ears to circulator fraud. Here, objectors objected to 860 signature lines within candidates' 1,291 filed signatures. Following the conduct of a records exam, candidate was found to have 846 valid signatures, which is 346 above the statutory minimum of 500 per section 8-8 of the election code. The hearing officer acknowledges an email and statements by objectors declining to proceed on the remaining allegations within their objection petition beyond the signature lines addressed by the records examination. The hearing officer recommended a detailed ruling on the motion to strike, but in light of the objectors not pursuing their additional claims, the hearing officer recommends that the motion to strike be denied as moot. As a result, the hearing officer recommends, and I agree, finding candidate submitted 846 valid signatures, which is 346 more than the 500 statutorily required number of signatures. All other objections fail for lack of proof, and the objection petition should be overruled. The recommendation then is to overrule the objection, certify candidate's name to the March 2026 general primary ballot as a Democratic candidate for representative in the General Assembly for the 34th representative district.
Thank you, Marnie. Mr. Erdman?
I concur.
Do I have a motion, please?
Make a motion to accept the recommendation of the general counsel and the hearing officer.
A second?
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese, Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you.
Thank you.
All right, Barney.
So the next is my longest recommendation of the day.
All right, how
It's,
close is Bernadette?
Yeah, this is, I don't know where that is back yet. I think the plan is to take a 20 or 30-minute lunch break, but I don't know where the food is.
Yeah.
So up to the chair whether I should proceed.
All right, do this one and then we'll probably be ready.
Sounds wonderful. My voice will be ready for a rest break.
Yes.
For this one. Hoppus versus Pierce, 25 SOEB GP 569. Is Attorney Olswang here?
Hello, Attorney Hendricks. I did file my.
Oh, yes, okay. I have that written down right here, so thank you. I will read my recommendation and then the parties will have an opportunity to address the board. So the petitioner, who is represented by Attorney Daniel Olswang, OLSWANG, with an appearance filed yesterday by Attorney Hendricks, who can spell his own name when we get to him, filed an objection to the nomination papers of candidate Pierce, a Republican Party candidate for the office of representative in Congress for the 11th Congressional District, and who is represented by Attorney Jeffrey Meyer. The objection alleges, first, that the petition does not conform to format, content, heading, and size requirements. Second, that the candidate has insufficient signatures. And third, on information and belief, that the candidate provided a false residence address in the nomination papers. So in this case, I fully agree with the hearing officer's ultimate recommendation, which is to overrule the objection and certify the candidate to the ballot. But my recommendation on resolving candidate's motion to strike and dismiss is different than the hearing officer's recommendation. I did let the parties know about this, so they'd have an opportunity to reflect on how they think the board should be ruling on the motion to strike in this matter. So candidate's motion argues that the objector fails to fully state the nature of the objections and that objector's interest is not sufficiently stated as required by section 10-8. Candidate cites to a 1995 Chicago Electoral Board decision called Gaffney versus Peters, GAFENEY versus Beavers, BEAVERS, which is cited in page 294 of your packet, for the contention that pleading residence in the relevant district does not adequately state an objector's interest. Now, the objector responded to the motion to strike, citing Harned versus Evanston Municipal Officers Electoral Board. Harned is spelled HARNED. This is a 2020 published appellate decision cited on page 294 of your packet, which held that objectors to a local referendum petition sufficiently stated their interest in the objection under section 10-8 by alleging they were registered voters in the relevant districts. Here, the objector argues that reading the objection petition as a whole, as required by Harned, the interest requirement was met by objector, alleging she is a Republican voter in the relevant district. The objector also argues that candidate is on sufficient notice that candidate's residency is at issue in this matter. In a response brief, the candidate argues Harned is distinguishable from this case and that it involved a ballot initiative petition and not a candidate petition, and that candidate ballot access is a substantial right. The candidate also cites to a 2004 unpublished appeals court opinion called Robles versus Hill, ROBLES versus HILL, cited on page 295 of your packet, which determined that stating an objector's interest is a mandatory requirement of section 10-8, which I don't think anybody disagrees with. Well, I guess you'll let me know. The hearing officer recommends the following disposition on the motion to strike. That the objection petition should be stricken and dismissed because it does not sufficiently state the objector's interest under section 10-8 of the election code, citing to candidates two cases, Gaffney and Robles. The hearing officer distinguishes Harned because it involved a ballot initiative petition. An objector's candidate petition should be held to a higher standard because ballot access is a substantial right in Illinois, not to be lightly denied. The hearing officer also recommends granting the motion to strike the portions of objector's petition relating to nonconformity of the form, content, headings, and size of candidates' petitions as failing to sufficiently state the nature of the objection under section 10-8. On the merits, the hearing officer recommends finding that the remainder of the objection is sufficiently pled, but should be overruled because candidate filed 1,558 signatures, which is 759 signatures over the statutory minimum, 799. I recommend an alternative disposition on the motion to strike because I believe that Harned is binding precedent, whereas Gaffney is a Chicago Electoral Board decision and Robles, a Rule 23 unpublished appellate decision, are at best persuasive authority. And also Robles does not address the issue of how much information an objector must plead to satisfy section 10-8's pleading requirements. It only holds that they in fact must state their objector interest, and that doing so is a mandatory requirement. So the Illinois Appellate Court in Harned held that under section 10-8, an objector sufficiently states their interests by alleging they are a registered voter in the relevant district. Where judicial interpretation of statutory language exists, administrative agencies are bound to follow that judicial interpretation, citing two cases, Caterpillar Inc. versus Fehrenbacher, Fehrenbacher, and Lawrence versus Illinois Human Rights Commission. Lawrence is Larrance. Both cases are cited on pages 296 of your packets. Here, the objector also alleges she is a member of the same political party as the candidate, giving her an additional interest in this proceeding. I do not advise disregarding the only binding precedent on this issue, which is Harned. The language of section 10-8 requires the same objection petition requirements, regardless of whether objecting to a candidate or to a ballot initiative petition. I agree with the hearing officer that the objection petition's allegation of nonconformity, however, should be stricken for failure to adequately state the objection, as the objector does not identify any specific problem with the form, content, headings, or size of candidate's petition. So here is a summary of my recommendation on the full case. First, find objector sufficiently stated her interest under section 10-8, citing to Harned. Grant candidate's motion to strike the nonconformity allegations for the reasons stated by the hearing officer. Deny the remainder of candidate's motion to strike because the rest of the petition was sufficiently pled under section 10-8. Overrule the objection because objector failed to prove her residency allegations, and candidate filed 1,558 petition signatures, which is 759 over the statutory minimum of 799 required under section 7-10B of the election code, and to certify the candidate to the ballot. Now, should the board choose to follow the hearing officer's recommendation instead and strike the objection for failure to plead objector's interests, I suggest deleting the ruling on the merits based on the records exam, because if the objector failed to state their interest in the proceeding, the entire objection is stricken and there are no merits left to reach. So if the parties have any comment on the differing recommendations on the motion to strike, they are welcome to weigh in on that for the board. And we go to the objector.
We'll go to the objector, Mr. Jeffrey.
No, I'm the candidate.
You're the candidate.
Yeah,
All right,
candidate,
Mr.
that's fine.
Hendricks. All right, I couldn't get.
And Mr. Hendricks, if you could spell your name for the board.
Yeah, sure. Eric Hendricks representing objector, last name Hendricks, much like Jimmy, significantly less.
And speak to the green
And I was
light.
gonna say, and I.
No,
read-
just
Nope,
definitely.
standing.
The green light above you.
That's all right. Say it to everybody.
And I recommend
At least I'm on social.
speaking loudly.
Yeah, we have a hidden microphone we keep in the ceiling.
Yeah.
We all have to look for it.
So, first off, thank you for taking the time out of your day. I know this is a lot of work, a long day. Sounds like.
Council, you want to keep your voice up?
I apologize. I'll speak louder. So, thank you. Like I said, I represent the objector, Tammy Jo Pappas. I recommend, or I agree with the general counsel's recommendation as far as the finding the objector sufficiently pled her interest. I think hard it's binding. Frankly, Robles is a Rule 23 opinion. I'm not quite sure how it would be interpreted in the context of this board, but as far as the circuit court is concerned, it wouldn't be, it wouldn't even be persuasive. It's the most relevant case on the topic. It's also the most recent case on the topic, and it comes out of the first district. So on top of everything else, we even got the right circuit court. As far as the recommendation of whether the allegations were sufficiently pled, I agree with the hearing officer. We did sufficiently plead as to the signature and as to the residency allegations. We don't agree, but we're not going to waste our time orally arguing the nonconformity issue. The signature and the residency are related. Essentially, the way the hearing officer interpreted it, which is correct, is that we were basing this, saying the signature, all the signatures were invalid based on the false listing of the candidate's residential address being addressed in Naperville versus being in Belvedere. This was on the statement of candidacy. This was also on the top of every petition. Section 710 of the election requires not just petitions be filed along with the statement of candidacy, but it provides a remedy. Earlier, the general counsel referenced, I believe it was East Jackson, there was a case, but essentially the requirements of 710 have been interpreted. Mind you, in that case, it was interpreted as mandatory and strictly construed, but that was regarding, it arguably was limited just to the signature requirements. But I think the logic applies elsewhere, and frankly, that court wasn't asked to consider the broader ramifications of it. So when we have a mandatory provision, there's two ways that we can address it. It's either through strict compliance or substantial compliance. Here, we have neither. Strictly construed, the address as alleged is incorrect. Therefore, the oath in the statement of candidacy is false, and it's required the candidate file that, along with listing the residents on the top of every petition page. This can lead to voter confusion. This can lead 30 more seconds. This can lead to voter confusion. This can lead to misleading the public. It completely contravenes the purpose of it. And for that reason, it was sufficiently pled. Unfortunately, we never actually got to an evidentiary hearing in this case. We had the motion was decided strictly to be dismissed in its entirety, or the objection was deemed to be dismissed in its entirety or recommended by the hearing officer solely because of the pleaded interest issue. But with Harded and the general counsel's recommendation that if you accept that, that the recommendation of the hearing officer itself is moot.
Thank you, Mr. Hendricks. Mr. Meyer.
May I ask a quick question?
Yes.
Did you ever request an evidentiary hearing?
We didn't, because what wound up happening was it was just denied on the motion to strike based on the insufficient pleadings, whether through interest. And it was specifically, we even specifically asked the hearing officer for clarity, this won't be like a dual motion to dismiss as well as motion or hearing on the merits. He exclusively limited it to just the sufficiency of the pleadings. And he actually, on top of it just being obvious that that's what happened, he specifically noted in his opinion or recommendation that he wasn't considering the subpoena materials and other materials that were attached because of that.
Well, we'll hear from Mr. Meyer.
Okay, Mr. Meyer.
Thank you. Good morning again, or good afternoon. I don't know when it is yet. Sorry to be interesting again. I seem to have this affliction when I come before you occasionally. Suffice it to say that at the end of the day, we agree with the ultimate recommendation from both the general counsel and from the hearing officer that this objection be stricken and the candidate's name be certified to the ballot. We respectfully disagree with the general counsel's position as to the strict application of Harned. We believe the hearing officer's reasoning is sound. I'll speak to that just briefly. The statute itself enumerates really 5 things. Statute itself, and I'm talking about section 10-8. First, there's a requirement for standing. Any legal voter of the political subdivision or district in which the candidate or public question is to be voted on, having objections to any certificate of nomination or nomination papers or petitions filed, shall file an objector's petition together with, and it goes on. That's a standing requirement. Okay. In other words, to have standing to file an objection, you have to be a legal voter in the political subdivision where the candidate has filed their objections. 10-8 then goes on to specify the content, what must specifically be pled in that objector's petition. Oh, I apologize. It then enumerates 4 things. The objector's petition shall give the objector's name, number 1, and residence address, 2. Shall state fully the nature of the objections to the certificate of nomination or nomination papers or petitions in question. That's number 3. And number 4, shall state the interest of the objector and shall state which relief is requested of the electoral. Okay. In other words, standing, saying this is where I am and I'm a voter here, is a separate requirement under 10-8 than the interest. Because the statute uses different terms and enumerates different requirements, they have to mean different things. This is a basic statutory construction requirement. And the our Supreme Court, I'll cite Cook versus it's COOKE versus Illinois State Board of Elections, it's 2021 Illinois IL 125386. Talks about the application of the rules of statutory construction to the interpretation of the election code. And as with any statutory construction, the fundamental rule is to ascertain and give effect to the legislature's intent, and the best indicator of that intent is the statutory language given its plain and ordinary meaning. No part of a statute shall be rendered meaningless or superfluous. The problem with the application of Harned in this context, or with the way that the general counsel is asking you to apply it, is that it would render the separate and distinct requirement in 10-8 that the petition state the interest of the objector. It would render that superfluous because the standing requirement would also satisfy then the pleading as to your interest. Harned, and I know that the general counsel believes this is not a legally significant distinction, but I believe it is. That is a case talking about a ballot question, public question, okay, versus whether or not a candidate's petition should sufficiently place them onto the ballot as a candidate. I apologize. The interest of a person on public policy, a tax referendum, is different than the interest of a person saying, I don't think these are qualified candidates being on a ballot. I agree that Harned says that there's no magic language, but notwithstanding there not being any magic language, interest still has to be articulated. And simply saying, I'm a voter is not stating your interest. Even saying I'm a Republican voter is not stating your interest. It doesn't say I'm concerned about only valid candidates being on the ballot or what other language you choose. And for those reasons, we ask that the objection be stricken. Thank you.
Okay. All right, we're going to need a distinct, well, they're all distinct, but we need a very specific recommendation, won't we, between the two, whether we recommend our general counsel or we recommend the hearing officer. So do I have a recommendation?
I just wanted to clarify, Marnie, thank you. Just a question about the request or lack thereof for the evidentiary hearing in light of, is it Harned? What's
Harned.
Harned decision. Do you have, can you provide some guidance on that?
I'm concerned by what the objector said, that they were not giving a hearing, but if they didn't request a hearing, it's hard to say that that's error.
May I comment on that briefly?
Yes, go right ahead, Mr. Hendricks.
Thank you. I guess I would just counter with, of course, we requested a hearing. A motion to strike, for some pleading deficiency is, procedural, but just by merely filing the objection, we were asking for a hearing on the merits. Now, candidate could have waived all of that if they had not filed a motion to strike. So the motion or the evidentiary hearing was requested. It was requested on the day we filed the objection. And just because there was a procedural roadblock along the way, just like in court, if your case is dismissed because, a pleading deficiency via 2615, you wouldn't then request an evidentiary hearing. You would appeal, which is what I'm trying to do with you all.
So can I
Wait,
clarify?
whoop,
Go ahead.
Jennifer, do you continue?
No, I appreciate your response. I would love to hear your response to that, Marnie. Yeah.
Can I just clarify? So what you're saying is that when you filed the objection, each and every stage along the way, your objection is supposed to actually flow as your, eternal request for every hearing along the way that's possible?
May I answer?
Yeah.
So yes, when you request a hearing once, and it's when you file. The roadblocks to get there are all procedural, and it's governed by rules, or whether it's civil code of procedure or the electoral board's rules, but it's all procedural. The motion to strike is, just to put it bluntly, it's an attempt to avoid that evidentiary hearing that has been requested by dismissing it before we even get to that topic. But it is requested immediately. That's why it's called an objection. We're objecting. We're requesting the ruling on the merits. Hearing officer never had that. We never had that opportunity. It was stricken solely on the motion to strike, which the general counsel has recommended. We agree with the logic of it that we did sufficiently plead our interest, and Hearted is binding.
Well, I don't know if I necessarily agree with that, but I'll let you weigh in, Marty.
So if I was representing an objector in a case and I was told by the hearing officer that I was not going to be allowed to present my evidence because an erroneous ruling was going to be made on the motion to strike, I would say I would like to do an offer of proof to show what my evidence is to the candidate to make the record. So that way, when it goes up on appeal, it's clear what evidence there is. That's what I would have done. If you weren't a lawyer, I might feel differently, but you're a lawyer.
May I just comment on that very
Quickly.
briefly? So I guess what I would say to that is, again, in the court system, you'd be appealing it. You wouldn't necessarily be making an offer of proof. Also, this was never set for evidentiary hearing, so there was no opportunity to do an offer of proof. The decision was solely on the legal question of whether the interest was pled and whether it was sufficiently pled or sufficiently stated. There's no opportunity to offer proof of it for an offer of proof for an evidentiary hearing when there's no evidentiary hearing set. That would be, in my opinion, respectfully, I think that would be more appropriate if evidence had been objected to and sustained. I would then offer the offer of proof.
You can make an offer of proof at any time during the hearing.
But there was no hearing. It was a hearing on the motion, not a hearing on the evidence, on the merits.
But you were in a hearing.
We were in a hearing for the motion to dismiss based on the legal question of whether we sufficiently stated our interest. And it was specifically set for that issue only.
But you're just your minor.
I was going to say, it does not relegate you to or prevent you from asking to make an offer of proof while you have the parties present.
That's true. I'll concede that, but also there's nothing in the rules that require us to do that. And frankly, we're able to make the exception to you, the board, and that's what we're doing. We're arguing our case. If you deny with the logic of it, that's one thing. But I do take exception to the fact that essentially an erroneous decision on or in my opinion, an erroneous decision on a legal question somehow puts a new burden on us to proceed with steps that aren't anywhere stated, anywhere in the rules, anywhere in the Code of Civil Procedure, in circuit courts, or anywhere else.
Yes.
Member Craig.
Ask a question to Marnie. Given all the back and forth, and I think there's a lot of legal things that I think we need to look forward. We need to look forward and say, hey, this happened this time. Okay, having said that, can we make a motion to put the candidate on the ballot just in light of the signatures they have? Or do we have to answer all of these questions today?
So we have to rule on the motion to strike. And we have to decide if the objector is still here saying that the candidate filed a false residency, then we do need to decide whether they were denied an opportunity to be heard on that issue. But I'd like to hear what Mr. Meyer says. And just one other point to make, you know, as I made to Mr. Meyer in a case earlier, I wish Mr. Meyer had filed exceptions for me to tell me about the problems in the hearing so that I could have time to prepare. And in that, it was a pretty minor error that I was able to fix on the fly. But here, exceptions would have gone so far in helping me understand, you know, what to handle in this case, how to research the best next steps. And here I am trying to do my best on the fly. But I'm curious what Mr. Meyer thinks.
Mr. Meyer.
Thank you. The hearing on a motion to strike and dismiss was heard over a month ago. The hearing officer's recommendation was issued, I believe, within a week thereafter. In the context of an electoral board case, 3 to 4 weeks of time is a long time. The candidate, the objector here has known for that entire time that they were not getting, or there was no scheduled further hearing. They made no further request. They could have said, great, we need to build a record. We want to build a record. They could have submitted a written offer of proof. If they didn't think they had an opportunity to hear, and I disagree that they didn't, but if they didn't think they had, they could have filed that at any time. They could have attached it to their exception. That's the entire purpose behind an exception. They've had ample opportunity to put that before you. Now they want you to effectively reopen a hearing a month after this case was effectively disposed of it with a different hearing. It's egregiously unfair to the candidate. It's unreasonable in light of the election calendar. They've had ample opportunity to put this in the record. They haven't, and now they want to argue facts that aren't even here in the form of an offer of proof. It should be denied. Thank you.
2 seconds.
What's that?
Did you want to say something? 2 seconds. I mean, quick.
Yeah. First, the board's rules don't allow for us to take exception right here now, which is what we're doing. We are establishing the record now. And if you'd like an offer of proof, I'm more than happy to give it to you now. You guys are the final decision-making authority. But again, nothing was violated. The only thing that happened was the evidentiary hearing, which is required to be held. Absent a motion to strike, wasn't held.
Okay.
I don't necessarily disagree with Mr. Meyer. There are steps that could have been taken, to your point, to file exceptions, to bring this to the general counsel's attention. Today is not that day.
Right.
It should have been done prior to this. This is too late in the game to bring those exceptions or an offer of proof to lay in front of us. It should have been done prior to this.
And another thought is if the board wants to adopt the hearing officer's recommendation on the motion to dismiss, this problem goes away because then the objection petition is stricken. I don't think that's the right result under Harned, but it is an option that's out there.
Okay. There's a disagreement between the hearing officer and Harned. Okay. So do I have a motion? Will someone state a motion?
I will make a motion to accept the recommendation of the general counsel, finding the objector sufficiently stated her interest under section 10.8 and grant the candidate's motion to strike the nonconformity allegations for the reasons stated by the hearing officer, deny the remainder of candidate's motion to strike because the petition was sufficiently pled under section 10.8 and overrule the objection because A, objector failed to prove her residency allegations, and B, candidate filed 1,558 petition signatures, 759 over the statutory minimum of 799 required under section 7-10B of the election code. And the last and final point of my motion is the most dispositive.
I love that motion. What kind of motion?
Last and final is the signatures, and that is most dispositive of this motion.
Yes. Do I have a second?
Second.
Is there a second? Did I hear a second?
Yes, second.
Who seconded?
Member Genovese,
All right. Amy, roll call?
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese? Yeah. Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson?
No.
Thank you.
Yes.
Motion passes.
Thank you. All right. Now, we are going to take a quick kind of 15-20 minute break before we finish up for today.
I vote for 20. I could use a voice rest.
Oh, for 20? Yes. Yes, 20 minutes.
Thank you.
So let's see, I don't know, have a clue what time it is. It's 12:25, so we'll say 10 to 1, right?
Thank you.
All right, it is 10 to 1 or past, and we will reconvene. And we will start with 3T as in Tom. Marnie, if you want to begin.
Thank you. This case is Suitors versus Brown, 25 SOEB GP 570. Here the objector Suitors is represented by attorneys Daniel Olswang and Eric Hedrick. The objector alleges candidates' petition sheets do not conform to statutory requirements for format, content, heading, and size, which I'm going to call non-conformity allegations. And the objector also challenges individual signature lines within candidates' petition sheets. The candidate is represented by Max Solomon, who filed a motion to strike and dismiss objector's petition. The motion asks the board to strike the objection, alleging it is an impermissible shotgun objection, and the line objections are made on information and belief, which objector says is impermissible. Oh, excuse me, which candidate says is impermissible under section 10-8, and that there is no record of the objector viewing signatures or other voter registration data at the county or state level. The candidate cites to Daniel versus Daly, DANIEL versus DALY, cited on page 335 of your packet, as supporting her contention that objector's petition should be dismissed in its entirety.
Different case, different type of case.
Objector's response to candidate's motion distinguishes her objection from Daniel versus Daly based on the type of line objections made. Here, the objections were based on district and residence, whereas in Daly, the objections were to the genuineness of the signature. An objector argues the results of the record exam support the reasonable inquiry with which the objector made those objections. Further, the objector states that her petition is sufficient under section 10-8 and argues making the allegations on information and belief is not prohibited. The hearing officer recommends granting the motion to strike as it relates to objector's nonconformity allegations, finding that objection petition has no detailed basis, fact, or allegations regarding nonconformity. The hearing officer recommends denying the remainder of the motion to strike, finding the remaining allegations within objector's petitions are sufficiently pled under section 10-8 of the election code. A records examination was held. 231 of the 337 line objections were sustained, resulting in 787 valid signatures within candidates' nomination papers, which is 12 below the statutory minimum of 799 per section 7-10B of the election code. The candidate timely filed a Rule 9 motion seeking to rehabilitate 22 signatures on the due date of November 26th, but the candidate did not attach the Rule 9 evidence to the motion. Rule 9G3 requires that evidence that will be presented at a hearing must be submitted no later than 5 p.m. on the last day of the Rule 9 motion period, unless extended by the board for good cause shown. Candidate's Rule 9 motion referenced Will County voter records, but candidate's counsel did not actually request a Rule 9 subpoena to Will County until after the Rule 9 motion was filed on the due date of November 26th. Will County then received the subpoena, both requested and issued on November 26th, and later produced the voter records on December 2nd. So during the Rule 9 hearing, the hearing officer granted the candidate's motion to rehabilitate 6 signatures and denied 14 others, 1 for lack of foundation, 5 for failure to meet her evidentiary burden, and 8 for untimely produced evidence, which is the Will County voter records. The hearing officer recommends taking the results of the record exam in conjunction with his recommended findings following the Rule 9 hearing, finding that candidates' petition sheets contain 793 valid signatures, which is 6 fewer than the statutory minimum of 799 signatures. As such, the hearing officer recommends that the objection be sustained and the name of candidate not be certified to the March 2026 general primary ballot. Candidate filed a written exception to the recommendation of the hearing officer, arguing the untimely Rule 9 evidence was the fault of Will County. I disagree. The candidate did not request a Rule 9 subpoena until the date of the Rule 9 deadline and only after filing the Rule 9 motion. Candidate's own delay in seeking a subpoena caused the untimely submission of evidence. Otherwise, I find candidates' remaining exceptions are either insufficiently explained or contrary to the rules of procedure. But the ultimate recommendation is to sustain any objection and that the candidate certified. And one other point is to grant the motion to strike in part and deny it in part, so that the candidate Brown is not certified to the ballot as a Republican Party candidate for the office of representative in Congress for the 11th congressional district.
Thank you, Marnie. Mr. Hendricks, for the objector. Mr. Solomon.
Hello, Eric Hendricks, representing objector, HENDRICKS.
Do you have any comments prior to?
I'd like to reserve my time to my opposing counsel says first, but we do recommend that you proceed with the hearing officer and general counsel.
Got it. Mr. Solomon, please.
Thank you, Madam Chair, Board. Good afternoon. Obviously, we disagree strongly with the recommendation of the hearing officer in this case. And may I clarify for the record that the Rule 9 motion that was filed included evidence, but the only ones or the only documents that were not attached to the Rule 9 motion was the Will County. All of the counties, McHenry County, Kane County, were attached at the time. Now, and that's where I'm going to start with. The Will County responsive documents to the subpoenas. If this board were to allow, which we offered as offer of proof, we made an offer of proof of at the Rule 9 motion. If this board were to allow the 8 documents that were produced by Will County, this candidate will make the ballot. She's 6 down. We produced 8 documents to reinstate. And if this board would move the offer of proof to evidence right now, this candidate will be there. And here's why this board should reconsider that. We're talking about subpoena for Rule 9 motion purposes. The rules are clear, and I'm going to cite to the rules. The first rule is 8B, Rule 8B, procedure for Rule 9 subpoenas. There is no time stated in that rule, 8B, when the Rule 9 subpoenas should be submitted. Rule 9 motion subpoenas, not general subpoenas, which are subject to Rule 6. That was the one that you have to file before 5 a certain day, and the objector would have a certain 24 hours later to object to it, and then the board will make a recommendation. That's Rule 6. For Rule 9, it's clearly stated in 8B that all the candidate or objector has to do is file a subpoena. What led to this subpoena? Will County refused. And by the way, the objections are the nature of whether they're registered to vote or whether they live in the district. These are not signature objections. These were, are they registered to vote or are they in the district? We requested those documents from Will County. Will County denied the candidate and told the candidate that the Board of Elections has instructed Will County not to release any documents to candidates or even to the attorneys. I immediately.
That's what the clerk, go ahead.
That's what the clerk of Will County said. And I'm saying that on the record. And it's emailed. It wasn't even told to us, it was emailed. I immediately, because normally you wouldn't need a subpoena to go get records of registration, especially if it's just about they're registered to vote. I immediately, within the Rule 9 motion period, filed subpoenas and granted counsel, general counsel to the board. It was approved immediately. It was the fastest approval for a 9 motion subpoena that I've ever seen. And here's the interesting thing why this board should reconsider. According to the rules, the objector had 24 hours to object to my subpoena. In this case, they didn't get that because as soon as I filed the subpoenas, an hour later they were approved. So the board couldn't have intended for these subpoenas to have been untimely if it gave the objector 24 hours to object to it and then additional time for the board to decide whether it will be approved. That was one. Number two, we had already filed in our Rule 9 motion what we intended to do. We stated what line number, signature number, and these were not signatures. Finally, Will County submitted the subpoenas, responsive documents to council. They wouldn't even give it to me, and I was council that requested it. They emailed it, and council had to send them to me. They didn't send it to me. Council had to send it to me, and we're asking now that the board just accept the Will County documents, and that's all we're asking. If the Will County documents were accepted right now, the candidate makes the ballot.
May I ask a question?
Sure.
What is the name of the, I recall someone at Will County emailing me. Do
Yes.
you remember that person's name so I can look up the email?
Karen?
Patty, I sent my, check it really quick.
That'd be great.
Yeah.
Thank you.
Yeah.
That's very different than my recollection,
I
but that's why I want to check.
and you had sent them to me because she would refuse to send them to us.
Mhm.
She sent them to you, and you sent them to us. And you uploaded them in the portal for us.
Well, that is
Thank
normally the subpoenas do say they're returnable to us, so that's not unusual, but I
Wasn't
tried to be
involved.
very fast.
Is it usual for a clerk to refuse to give information?
I can't give a clerk advice as to whether or not there needs to be a subpoena. The clerk is supposed to be talking to their state's attorney on whether that's required or not.
But you have an email that says they were instructed by us.
Yes.
Not to give anybody anything.
Yes.
You do have that email.
It
Yes.
doesn't say that.
One other question, for the other counties, did you have to do subpoenas or?
No, we went to the other counties, they gave us the documents we needed easily, we included those in our motion. And in my motion, I stated in there, subject to subpoena. So I didn't file the subpoenas after the motion. I actually stated in the motion that I've already requested subpoenas.
I'm trying to find it as well. Maybe I can try by the case number.
570.
And there was a string of email that you and I were on with the clerk.
Sure.
Was saying that she won't release them to me and that
Brooks County Clerk is Annette Parker.
It
was a deputy.
I think it was, yeah, it wasn't her.
I think her name. Is it Rosa Whalen?
No, I think it's
I'm sorry to make everyone bear with me, but.
No, I want to
These
know.
6 signatures or whether this candidate's on the ballot or not, so I think that everything is really important
Take
here.
your time. I
So,
like the actual facts.
I would too.
me too. Kimberly,
Yes.
okay.
okay, let me, Gladhammer, let me find her. else.
December 2nd was the email strings, if that helps. One that she sent to you and copied me, but she didn't allow me access.
And again, I
I'm
can't
sorry,
help
I
it.
have it.
Okay.
Mary Patterson.
Patterson, okay.
Yeah.
Do you mind
Assistant Chief.
spelling that for me?
Sure, it's P like Paul, E like Edward, D like David, E like Edward, R like Robert, S like Sam, E like Edward, and N like Nancy.
E-N, okay. Peterson, whatever.
And I can read off what the email states if you guys want that record.
I think there were some emails that you were not
Oh, God,
necessarily on, so I want to make sure that you have the opportunity to see everything. Oh, okay, that involved, oh, this is about Mr. Olswing's subpoena.
It's not me.
I know. Bear with me for a moment. Oh, that's petition of Michael Pierce, different case.
December 2nd was ours, I think.
Okay, here we go. All right. I think I was conflating those two cases in my mind, so it's good that we checked this. All right, here is where Kimberly said Miss Matowitz misspelled. Attached, please find the subpoena issued regarding the above captioned matter requesting return of documents to the Illinois State Board of Elections. The link below contains the documents requested in the rider to the subpoena.
I responded because she didn't give me that link that she was talking about. I had no access. And she said, no, I'm gonna give it to you and you give it to me.
Right, and then I gave it to you right
And then
away.
you gave it to me. Yes.
All right.
Yeah.
Because, you know, the point is, I would never tell a county clerk that they can't give you records without a subpoena.
I don't know why they did it. That was.
Well, that's what I wanna hear Well, that's first. right. I can read
Yeah,
the
I
email,
wanna hear
because,
hers.
I called them first on that Monday.
Yeah.
Because that, we got the record examination on the 21st. So that Monday, I called them. They said we had to give them a call back, which was fine. They gave me a call back and asked me, could I email them the names, a list of names. So I emailed them the list of names on the 24th. On the 25th, they emailed me back and said, good afternoon. Under the advisement of the Will County State's Attorney's Office,
Okay.
our legal counsel, please be advised that our office is unable to release the requested records without a valid subpoena from the Illinois State Officers Electric Board. Once a subpoena is provided, we will review it promptly and respond in accordance with the applicable law. Thank you for your attention to this matter. Sincerely, Mary Pedersen.
Okay, great.
That was on the
That's
25th.
consistent with my understanding.
Okay.
I would never tell an electoral board that they're clerk that they can't give you records. I would tell them they just go to their state's attorney and get their state's attorney's advice on whether a subpoena is required. And it sounds like that's what I did.
Yes, ma'am.
So where? If did Will County then submit the names in proper timing?
So the last day, the day when these records were due, which was November 26th, was the same day that the Rule 9 subpoena was issued. It was then given to Will County, and Will County did not respond until December 6th.
But you did try to get them on the 24th.
Yes.
They only responded on the 25th.
Yeah. And so then when they emailed me on the 25th at 2:33 p.m., I called my attorney, emailed him the actual email. He then came, I guess, the next day and did a subpoena, because you said you wanted to do it before 12 p.m.
Right.
He went, did the subpoena. He called me right back. I guess it came back within an hour or two. About maybe around 2 o'clock. He said, Fedora, I got the subpoena.
Right.
Good. He emailed me the subpoena.
Right.
I said, do you think I have time to go to Will County? He said, probably not today, because I think they closed at 3:30. He said, but what about Friday? I said, no, I said Friday. He said, no, they're closed because it was Thanksgiving. I called them anyway. I talked to Mrs. Pedersen. She said, no, we're closed on Friday. So Monday was the 2nd. I got down there Monday morning and gave them showed them the letter, the subpoena. They then told me they couldn't release them to me.
Right.
I sat there, I called my attorney. He then he called the lady, whoever the deputy chief was. I think the Kimberly lady is the deputy. This is just the assistant. He contacted the assistant and he contacted the deputy. The deputy walked over to me and said, I cannot release these items to you. I will have to, she said, don't you see on there where it says, it has to be sent to the electoral board? But then next to it, it said, or pick up. And I said, or I can pick them up. She said, no, I will not release these documents to you. All I did was say, what do I need to do, Max? Max said, I'll handle it.
Right, and that's when I followed up with the email that was just read. Hey, she won't give them to me. She did send them to council, and council eventually sent them to me. And then I eventually sent them to hearing officer and told them what happened. It was the first time that I've ever, we're not giving them to you.
Great. Okay, so you got the subpoena on the 26th, is that right?
Yes.
Yeah, on the
And what was
26th.
the date of the motion?
The
December
Rule 9
2nd.
motion, the Rule 9 motion was also due on November 26th. So it's still true that they did not request the Rule 9 subpoena until the day the responses were due.
But she did try
But
to
she
get
did
it 2
try
days
to get it.
before, it's just the way that.
And then they were
Yeah.
going to
She wasn't
instructed about
Right.
So the
Right.
legal question here is going to be whether good cause existed for the late filing. And I will let the parties speak to that.
And I will be the first to go. That's based on the discretion of the board. The board has discretion on that. And Chairman was mentioning that earlier, that when it comes to the rules of the board has discretion. This is not a legal matter. This is not a section whatever matter in the election code. It was if we had filed a motion before the hearing board or the board and giving you a reason, would you have extended time? And I think you would have, and I think you should now. And that plea that this candidate should not be punished or
Mr.
something.
Hendricks, do you have comment, please?
Always. Thank you. Thank you again. Good afternoon. I guess what I'd say is one, the delay wasn't forced. subpoenas were due on November 20th. They waited, Rule 9, the regular subpoenas were due on November 20th. Rule 9 subpoenas were
Why
due.
would the 20th coming in here when it's the 20th?
The Rule 9 is for the regular subpoena deadline. The Rule 9 subpoena doesn't have a deadline. It just has a deadline for when the evidence is due.
Okay.
And the evidence is due on November 26th.
All right, continue.
Correct. So the subpoenas were late issued. They were returned the exact same day. What candidate is asking you to consider is essentially, I would object to the entirety of it as hearsay. We don't know what actually happened, first off. Second off, there were 331 signatures that the state records exam reviewed. Out of those, 231 of them were sustained in favor of the objector. That is two-thirds of everything that was reviewed was objected. So now he's asking you, not only do I need 6 signatures, but effectively they'd all go through. It's just not true. There were part of that subpoena material were for different names, different addresses. Cities were stated differently. Names were spelled differently. They might not have been registered at all. We don't know. And to then go back, it's essentially asking us to, what candidate's asking is for you to go back, and there's a very thorough recommendation from the hearing officer. He considered all of this. There was an offer of proof, and he still denied it. And he's asking you to go, the candidate is asking you to go back, not only grant the subpoena or essentially allow for a late filed subpoena or late submitted evidence, but also just assume that they'd all go through. 2/3 of them were getting rejected. That wasn't even all the signatures we objected to. The records examination stopped that. But for those reasons, I would recommend that you adopt the position of the general counsel as well as the hearing officer.
That's kind of what I have a problem with right now. We don't know if Will County's information is going to validate these signatures, right?
They're not.
Or validate
The
the residency, sorry, the residency. We don't know that. And we can't make a ruling based on that.
So I thought I had understood from Mr. Solomon's argument that the hearing officer had done some sort of alternative
He didn't.
finding of ruling of those.
He
6
didn't at all. He
signatures.
rejected them, but accepted them as offer of proof only to preserve them for the board.
Okay,
That's all he did. He didn't go into the merit of them, but they were not signatures. He
Okay.
did say that.
okay, but you did make the offer of
I
proof
did,
based
I
on the
did.
voter record.
On the voter records, certified voter records, yes.
Okay.
What is our procedure here? Is what my question is. If we have this information from Will County now, it has not been reviewed by us. We cannot make a ruling on that if it's not been reviewed by us.
The threshold question is whether good cause existed for the late filing. If you decide there was no good cause for the late filing, then the
objector wins.
because it's not proper to consider those 6 signatures.
Right.
Now, if
Eight.
eight signatures, sorry about that.
Good.
Good correction.
Who has them now?
Thank you for everyone for thinking this through with me. This is a lot, obviously, but it's important and we'll get down to the bottom of it together. So, but if the board determines that the delay was for good cause under the rules, then I think that the remedy would have to be a remand to the hearing officer to consider those signatures. And the issue with that is the ballot certification.
Right.
So my next question is, under the Open Meetings Act, we normally need 2 days notice to put a case back on the agenda. But there is an emergency exception under the Open Meetings Act that I don't know off the top of my head, and I don't know if it applies here. So we could give me a few minutes to read the Open Meetings Act.
I have another question, just for clarification before you do that. When was this hearing conducted?
December 11th.
Okay. And when was your,
Will County submitted documents December 2nd.
well, when was your Rule 9? So your Rule 9 hearing was on December 2nd.
December 11th. So December 2nd came in, and good question. December 2nd came in based on the hearing officer's prior order that we would do a telephonic status call on December 2nd. And that was why Will County did it on the 2nd. But the hearing for the Rule 9 motion proper was December 11th.
Okay, all right. When was the original hearing?
December 11th.
And when did you file your exceptions?
Right.
After his recommendation.
Okay. I
I
can,
think it was December 17th. He did his recommendation 17, and I filed my exception same day or maybe 24 hours later.
okay.
Okay.
So should we take an initial vote on, do we think there's good cause?
I think
the
that's a good
delay,
idea.
And then we'll see where we are.
We're here.
That's a good idea. I want to make sure you've had your opportunity to weigh in on this issue.
Well, I think we're unnecessarily complicated. The rules say it had to be done by a certain time. It was thoroughly considered already by the hearing officer. Like, again, wrote, I believe, a 9-page recommendation, which considered this. And on top of all of that, to then send it back to review these select 8, we knew we had won. And so now the objector would be getting prejudiced because there were opportunities for us to continue on, invalidating signatures left and right, but we stopped because we knew we had it. At a certain point, we count.
We don't know she has it with these 8, right? Because nobody has seen it.
Right.
Right? Is that correct?
That's true. Yeah.
I have another question though. The November 21st record exam was held,
Yes.
correct? Were you both present for it?
Yes.
Okay. And,
I was not present.
okay,
Oh, he didn't file his appearance until the morning of
Okay.
April 9th.
regardless,
Oh,
all
okay.
right? My next question is, is there a prescribed amount of time when you can file for a Rule 9 hearing?
Yes.
So yes, so 3 business days after you are given the results of the records exam.
Okay,
So that due date was November 26th. And what the rule says is that on that due date, you must have actually presented the evidence itself. It's not enough to just say,
gotcha.
I'm gonna give you the evidence. You're actually supposed to say, here's the evidence.
Okay, I just wanted that clarification on that time frame so that I can understand. The hearing officer said it was timely filed by Mr. Solomon, but I don't know what that means. So that's why I wanted to understand what that time
Right,
frame looks
so
like.
the motion was timely filed, but then
The material was not.
the material was not.
I see. Okay,
Just those 8. Just those 8.
Just those 8,
Yes.
just to those 8, there was
Yeah.
other material
Yes.
attached to the Rule 9.
But how do you deal with the 8 with Will County refusing, but doing it on the, I mean, that's
up to us
that's
to
the-
decide.
that's us.
Good
Okay.
cause, that's the standard. I can't tell you what good cause means. You determine what good cause means.
Gotcha.
Sorry.
Jennifer, do you have a question?
I was gonna make a motion to find,
I can't hear you, Jennifer.
can you hear me now? No?
A little louder, Jennifer.
Okay, can you hear me?
Yes.
All right. So I will make a motion. Marty, help me through this. That to find that good cause has been presented for the delay of evidence for the Rule 9 motion.
That's fair.
And I will second it if that works.
Give me 1 second. I'd like to cite the rule that's relevant here.
9, that'll be Rule 9G5.
Good cause under Rule 9G5.
Let me just look at it for myself really quickly. That helps to. Okay, so
3 and 5.
9G3
and 5.
says evidence offered to refute the staff ruling, including affidavits, but excluding oral testimony that will be presented at a hearing after the evidentiary deadline, must be submitted in accordance with Rule 6 to the board or the hearing officer with a copy provided to the opposing party no later than 5 p.m. on the last day of the Rule 9 motion period, unless extended by the board for good cause shown. And then subsection 5 says extensions of time. If any extension is given to the candidate or objector to rehabilitate or strike any signature, then the opposing party's period to provide other evidence to rebut that submission shall be equally extended, which means that we would then have to give the objector an opportunity. Well, ballot certifications tomorrow.
I was gonna say, can we effectuate this?
I mean, to me, this is also, you know, causing some prejudice to the objector at this point. It's a sticky wicket. I'm glad I'm not a board member.
Well, I'd rather err on the side of caution.
What a
When we
baby.
certify the ballot tomorrow, I mean, we've all been here long enough to know that's not the final ballot. It's what we certify. There are pending court cases. So I'm not gonna lie and say giving them 24 hours is gonna kill a ballot. But I would err on the side of good cause. Oh, please go ahead.
All due respect, but the willingness to, I guess, extend the time here kind of contradicts my experience in the previous case where I actually didn't blow, there were no deadlines blown. And there was an artificial requirement to pursue further. I feel like the contemplated decision here is completely the opposite of what was held. So I'm a little confused, or maybe frustrated, a better word with that. As far as that's concerned, there was a deadline. The hearing officer considered this. Frankly, the exception was the first time that this was, I don't know if brought up's the right word, but there was no motion to extend time based on this. He went, got rejected, and then in the exception, after he got the ruling that didn't go his client's, or the candidate didn't go the candidate's way, now all of a sudden is taking an exception and essentially putting prejudicing objector when two-thirds of the signatures were already knocked off. It completely annihilates the entire strategy. Like, I would argue that if you do this, you'd have to redo the entire hearing, which I think is basically free.
This is where I've been trying to get from the very beginning.
Okay, that there.
What is our procedure? Was it followed? And is it followed to today? Or do we have good cause to go back and say, even though procedure was followed to the letter, we still have good cause? And that's what I need to understand. I've been asking, and I'm not sure if I have that answer yet.
May I respond really quickly to what you just said? Just three things. Number one, it is established in Illinois law that access to the ballot is a substantial right that cannot be
Yes,
lightly denied.
agreed. That is
It's
given.
great.
Yes.
Yes. To answer your question, yes, everything was followed. The deadlines were met, but for Will County. As council agreed and
But I'm
read
talking about after.
Yes,
Was
after.
there a procedure for objections? Was there a procedure for a request for extensions? Was there anything that was available to Mr. Solomon that he did not take advantage of?
No, and I'll answer that.
I would like to hear from general
Oh.
counsel, please. Thank you.
Okay, I think that's an excellent point that the objector just raised, is we're looking at 9G5. It says, if any extension is given to the candidate or objector to rehabilitate or strike any signature, then the opposing party's period to provide other evidence to rebut that submission shall be equally extended. But it also refers up to subsection 3, which talks about, let me read that. So the evidence must be submitted in accordance with Rule 6 to the board or the hearing officer with a copy provided to the opposing party no later than 5 p.m. on the last day of the Rule 9 motion period, unless extended by the board for good cause shown. Well, if you didn't request an extension of time, that does seem like a real error to me.
We didn't need it because we met time. Remember, we filed before noon. It says 5 p.m. We filed. We didn't need extension.
You filed the motion, you didn't
Right.
file the evidence.
No, we didn't file the subpoena, which gave us the evidence, but the subpoena doesn't have a timeline. HB. Subpoena under H6B has a timeline, but it's subpoena under H B doesn't. We didn't need an extension. We filed everything according to time. We even made an offer of proof. We even went to Will County and said, give them to the board. As far as we're concerned, on November 26th, we had done everything we could possibly do. Now, if Will County had responded to me like they did to you, we wouldn't be here.
But knowing on the day that you did not have all the proof that you needed and you were still 8 votes short, or 8, excuse me, 8 signatures short, or
Six,
requirement, or whatever.
No, we didn't know that.
Was there a procedure at that point in time that he could have taken advantage of to, for lack of a better term, motion up the case in front of the board on December 9th, when we were here last, to be able to request an extension of that time? Is there a procedure in place to do that?
So the rule hearing didn't happen until December 11th, which
Yeah.
was after. So that is one thing, but
But we're
looking,
not precluded from calling an emergency meeting or an emergency vote on something, correct?
I don't know, because I don't know if that's going to be okay under the
Gotcha.
Meetings Act.
Okay.
However, now that I'm looking at 9G3, it says that the evidence offered to refute the staff ruling will be presented at a hearing after the evidentiary deadline must be submitted in accordance with Rule 6 to the board or the hearing officer with the copy to the opposing party no later than 5 p.m. on the last day of the Rule 9 motion period, unless extended by the board for good cause shown. So I think that in considering whether good cause was shown, it's reasonable to consider, you know, as Kathy has suggested, whether everything was done that was supposed to have been done, and there was no extension requested, and there probably should have been, because we do know for certain that the objector did not have the evidence on hand on November 26th at 5 p.m.
So I appreciate the discussion. I think it's helpful. I will say there is a motion pending, so I think we just need a vote on it.
Yeah,
You know what I mean? Like, I get it.
Absolutely.
Restate your motion.
We'll try. Okay, I move that we find that good cause was shown under Rule 9G3 for the delay in producing the evidence.
From DuPage.
From
Will County.
Is there gonna be a finding of what that good basis is in this motion?
We don't need to show, we don't need to.
I was just asking a question.
All right, we have a motion. Do I have a second? We have a motion and a second. Amy?
Who
Roll call.
seconded it?
Chris Craig.
Oh, of Member Craig, okay. Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory.
No.
Mr. Brett,
No.
Ms. Watson,
Yes.
Vice Chair Turvin,
Yes.
Chair Donahue.
Yes.
Motion passes.
So,
Now
procedure
we're-
now.
And now, if good cause exists and redeeming this, these 8 records to be timely, the question is, what is the next step?
Yes.
If we could break for a couple of minutes, or we could hear the next case and then come back to this case.
I know, she had an issue, so.
We only got one more case.
I
right?
don't go to the next case, we'll come back to this and
We only got one.
We don't need a vote from Member Ballard Croft on procedure.
Well, Member Watson will have my proxy.
Okay, so.
Whatever you want to do.
I know, so.
All right, so let's go to the next one. And then we will come back to
If she has.
Mr. Solomon.
The hearing officer already has all these documents with him. All he did was he didn't consider it. So I believe strongly that if he reconvenes us over the phone later today or tomorrow morning, there are things we already have. We can go through them with the objectors counsel present. It's not gonna take 5 minutes for the 8 signatures.
But there was an issue that
Meeting
the
day.
opposition brought up, which said they haven't had opportunity for other, to rebut other things. And that's something,
And not to cause
don't.
a bigger
Go ahead.
but continuing it from December, well, whatever the date was in December, the 11th. December, no, when it was supposed to be turned, it was the 2nd, right? November 26th. The continuance to January 7th. I mean, so I'm gonna have a month and a half. You're continuing it
No.
a month and a half.
No.
What?
It says, if any extension is given to the candidate or objector to rehabilitate or strike any signature, then the opposing party's period to provide other evidence to rebut that submission shall be equally extended. So to me, that means the time frame between November 26th and December 1st. That's how I would read it.
I would read it as now, because this is what the board just did. They just granted it now. And if we get 24 hours to present it before Mike Texan, they get 24 hours to object it before Mike Texan, and Mike Texan makes his recommendation right back to this board.
I'm gonna have to do research on that and are there cases out there of whether, the electoral board must rule by tomorrow? I mean, this could be a case that it is too late. I just don't feel comfortable. I don't even know if I can put it on the agenda tomorrow, at this point.
Okay.
Maybe we continue it and give opposing counsel, myself, time to formulate an argument. As well as
Your arguments would be helpful
You don't
too.
need legal documents. You have the documents that were presented.
Sure,
He
but
doesn't want me.
I'm curious what case law says.
What I'm saying is,
Couldn't staff look at what he submitted, right?
Mhm.
See if it's relevant, and does what he claims it does.
And if it doesn't do it,
you have them. You have them already.
Yeah.
We offer them as offer.
Yeah, if you've got them on your email, you
But,
have them.
so if
they signed it.
if someone
Yeah.
comes back and says only 5 signatures are rehabilitated and she's still under,
Then we accept.
then are you okay with the idea of you still won but she's under 1
So
signature?
if you guys want to say we win,
You're okay with
then
that?
I am okay with that.
Okay,
I mean,
all right.
isn't the point is
I think that
just
needs to stop.
due process,
Yeah.
right?
This
That's
is
the whole, if you win, you win.
Could.
You know, if there's 5 signatures that they're rehabilitated or 5, whatever, then that's fine. But the rub is, do we really have all the information?
It is contradicted with the previous decision,
Yeah,
however.
I was just-
No, and these are not signature issues. And council would agree. These are not signature issues at all.
Their addresses?
They were address, not even addresses. They're
they were
registered to vote or is the address in district. That's it.
Okay.
No
I think I've been
signature.
consistent in
No, no.
what I have done, but I'm gonna let the process play out.
I have everything on my computer. We can do it. If this is gonna be the decision, I mean, I would need an equal amount of time. I can't waive that without talking to my client.
No, I completely understand and
Been a-
agree. I think the really quick question here is whether the Open Meetings Act would allow us to bump this
hang
case
on.
to tomorrow.
Member Turvin would like to be heard.
Sorry, I wasn't looking up. Mr. Turvin, give him a chance to, you are recognized.
Thank you very much. What I would like to request is that maybe the general counsel just take a timeout. Go figure this out, come back. We're coming back tomorrow anyway. All right, instead of trying to figure this out piece by piece, give you time to take a breath and take a look at it and look at all the files with everybody that's involved. Then get back to us and we can make decisions from there.
So I would love to do that if the Open Meetings Act allows us to put this case on.
Exactly. I agree with that.
So that is the question. And if we break for 5 minutes, I think I can get the answer to that. Yeah.
We'll have a hold here and let her, we'll take 5 minutes to look at the open meeting.
Because that's my preference, is to follow the vice chair's recommendation and to just recall this case tomorrow. But give me a minute, I'll read the Open Meetings Act. We'll see if this is an emergency.
And if I may add.
You know, Marnie, you may want to just call the hearing officer during that 5 minutes. Because he's got the documents already.
No,
So, by what? It's 1:35 now. By 3 o'clock, the hearing officer could have a ruling.
I was gonna say.
I really, I think it's a more complicated decision with that because the rule would require a like amount of time for the objector. So I think there's so many issues here that I'd like to I think everyone, all three of us would probably like the opportunity to wait till tomorrow to finalize this argument. Let's just see really quickly if the Open Meetings Act will allow us to do that.
Thank you.
As for us though, please let the record show that we don't need any additional time to do anything.
Sure.
We already have everything with you.
Okay, you have everything,
Yeah.
but the objector does not have everything.
Right.
They do.
Haven't considered it. No, because I might want to introduce new evidence.
Which I think you would be entitled to do, so.
Do you have the 8 names? Does the objector have the 8 names now?
Yes. No.
No, the
No.
objector. The 8 files.
Somewhere.
Okay,
So I can find.
okay.
Does he have them? I didn't hear that.
Yes, ma'am.
Can we take a 5-minute recess?
Yes.
Yes.
He does
Everybody-
not have them.
5-minute recess.
Springfield, are you? It's hard for me to see. I'm missing Rick.
Here, I'm here.
Oh, all right, there he is. All right, we are back together. Marnie, would you like to comment?
Sure. So thank you to Sean and Jordan for helping me over the break. What I learned is that the Open Meetings Act says, except in the event of a bona fide emergency, 48 hours notice shall be given of a meeting to be held pursuant to this section. And of course, this item would need to be added to an existing meeting as opposed to holding a new meeting. We're certainly already holding a meeting tomorrow. So the question is whether this is a bona fide emergency. I looked at case law. There is no case law on what is a bona fide emergency. Sean looked at the public access Bureau of the Attorney General. The only thing that exists on a bona fide emergency is in the health/COVID context. So I wish I could tell you more about what a bona fide emergency is, but the question becomes whether we can continue tomorrow is whether or not there's a bona fide emergency.
I think we just have to set precedent then. Make a decision. I mean,
I'm sorry, repeat that.
I think we have to just decide for ourselves whether this is a bona fide emergency. If there's no case law out there.
There's no case law.
So,
All right,
so do we need a motion on that?
There would need to be a motion.
do you have comments?
So what is it we need a motion for now?
Whether or not this is a bona fide emergency in order to put it on the agenda tomorrow.
Yeah.
You said there was good cause. Good cause. There was
Andrew, do you have comments?
Be allowed to argue.
I think we've all said enough. We're gonna have to make a decision. Springfield, Rick,
I think we have a bona fide emergency with good cause.
Is
Then-
that your motion?
That would be my motion.
Second.
been moved and seconded that we will discuss this further tomorrow, put it on the agenda.
Yes.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turvin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Now that we're here, let's get it done.
Okay, so we'll hear it. Let's hear it first thing tomorrow morning at 9 a.m. Will you be available or
I
not?
have court in Will County at 9 a.m. I was gonna suggest that we put it to the last call for tomorrow.
Is that okay?
I have pre-trial at 2.
What time will you be back from Will County?
Yeah.
I can be back here by 11.
Bring the clerk.
Yeah, right.
Good point.
11 o'clock.
I can be back here by 11.
Is that okay?
It just, I apologize, I'm sitting, it's rude.
Oh, no worries.
Just for my clarity, we're continuing to tomorrow to come to a decision or to whether it's, what's happening?
Tomorrow, you're gonna make arguments as to why you think that the case should not and cannot be reopened based on these 8 signatures or whatever else you want to argue, or argue that it's too late, or argue that it's prejudicial, whatever it is that you want to argue on behalf of your client. Max, I think, is pretty in good shape, he thinks. But what I need most is for me to do research on whether this is prejudice, whether we can not have an answer on ballot certification tomorrow, whether I'm supposed to be remanding this to a hearing officer or deciding it myself. I need to know all of those things, and I don't know all of those things off the top of my head.
And is it possible that you're saying if it was remanded, the hearing would happen tomorrow as well, or?
I would prefer that it not, although Max would prefer that it would.
Yeah.
So we'll argue about that tomorrow.
Okay,
What
we're
is
just,
the case?
we'll argue
Here,
tomorrow.
I'll tell you this, my recommendation is if 6 signatures are to be rehabilitated. 8, or at least 6
Right.
are rehabilitated.
Right.
My recommendation will be that you should get extra time to file at Rule 9. So I will not back down on that position. However, my position might be that it's over. So I'll let you know tomorrow.
I'd like to make sure that I'm clear about the record. in this
Madam-
matter.
Go ahead.
Everybody keeps saying signatures and signatures being rehabilitated and that kind of thing. My understanding is that these 8 have to do with objections that reference whether or not the voters that signed the petitions were in the district, that no signatures are in question. In which case, this board can determine tomorrow or this evening or now whether or not those 8 voters who signed live in the district. All of that could be done within the hour by this board.
So the objector is shaking his head no, and the candidate is shaking his head yes.
Good thing they don't vote. We do.
As far as the nature of the objections, as far as the nature of the objections, member Watson was right. These are not signature-based objections. All these 8 are they registered to vote at this address, or is this address in the district? That's it.
Or are they registered at all?
That's what I just.
Or are they registered at all?
Or I said.
Okay, and we all agree that those are the issue and
Those were the only 3 issues that were.
involved in 8 signatures. So the status right now is that the candidate is 6 signatures under the statutory requirement. So the ultimate question is going to be whether at least 6 signatures be rehabilitated. And if the answer is yes, then objector needs an opportunity to have his own Rule 9.
Madam Chairman, we have someone who wishes to speak.
Thank you, Jordan.
Oh, it's Jordan. Oh.
Hello. Go ahead, Joy.
My name is Jordan Andrew. I'm Deputy General Counsel for the State Board. I want to advise 2 things. During the break, I checked the page and line numbers indicated in the candidate's Rule 9 motion that indicated subpoena. Presumably, this chart identified the page and line numbers at issue here. I checked this against the record exam summary report, which provides a line-by-line breakdown of the rulings that were made during the conduct of the record exam. All of the page and line numbers indicated at issue here were the objection basis was that the signer is not registered at the address shown. There are no district objections. This is all whether the signer was registered at the address shown. Additionally, there was no voter record attached to the ruling, which means that the objection was sustained because we could not find, the staff examiner could not find a registration record associated with the address that appeared on the petition sheet. So this then leads to and this is where it is in my opinion, so take that for what it is. There are 2 questions then to be presented at the time of signature rehabilitation. Number 1, is there actually a registration associated with the address that appears on the petition sheet? And then secondly, is the person's name appearing on the page and line number the signer? And are those 2 questions answerable by the evidence proffered from the county clerk registration record? So for each of these 8 signatures, there are 2 questions that need to be answered. Is there a registration record produced and showing that someone is registered at that address? And is the person who appears on the list presented by, in this case, the candidate, also the person who signed the specific page and line that was objected to? So just to clarify, I took the break to actually look at the exact pages and lines and what the candidate has offered and what they're trying to accomplish through proffering the Will County registration records. I hope this clarifies a little bit of the issue and a little bit of the discussion before the board. Thank you.
Thank you.
And maybe I can make it shorter. I also just think based on that, it's impossible for the candidate to rehabilitate, even if theoretically, which we do not agree with, but even if theoretically all 8 were registered at that address, there's no way it would all be inadmissible. They'd never submitted any witness. They never tendered any of the purported signers an affidavit. They didn't call anyone to the hearing. How would they possibly get that into evidence without some sort of proffer? Or not proffer?
I just want to say, counsel, I practiced election law in excess of 45 years. I have in excess of 45 years. I have rehabilitated in circumstances very, very similar, 75 to 80 voters. So it's certainly possible. So I don't know what your experience is. And I am not saying that counsel has done what I usually do. He may not have. And he may not have what we need now that it is not in the district. Objections.
I
I'm
guess
simply saying that you're saying it's virtually impossible. I did it for years. So it's not even, it's absolutely possible.
I agree. It theoretically is possible. I guess what I'm saying is the November 26th was the deadline to submit witnesses. It was or December 2nd was the deadline to submit witnesses. It was the deadline to do everything. They have no witness who could possibly authenticate or lay the foundation for. They don't have an affidavit from Will County. They just have records.
The documents we submitted from Will County were self-authenticating.
We will find out tomorrow.
It's necessary.
All right,
to submit
Bernadette?
The rules of procedure to rehabilitate signatures on the basis of registration. The certified records from an election authority can do that. You don't need additional testimony from a signer or an affidavit. When the signature is not.
And even when the name and addresses don't match.
Upon reviewing what's been tendered, usually as part of that certified copy, there would be signature, which is usually why they do ask for subpoenas in certain jurisdictions. You would be able to see if that copy of that record from that election authority matches the signature itself, as well as the information that were included on the petition.
So the relevant rules are in our appendix to subsections B through D. Talk about these sorts of address issues. Jordan, anything else to add on that?
She's gone.
She's gone.
She's here. She's here. She is
Sorry,
here.
what was the question?
Do you have a response to the objector's claim that a voter record enough would not be sufficient to rehabilitate and that an affidavit from the voter would also be needed?
No, Bernadette in her explanation has explained the rehabilitation to my understanding. I agree with Bernadette.
Great, thank you.
All right, so we are moving this case till tomorrow, hearing this case tomorrow at 11 o'clock. As close to 11 as we can get with the other things that we're here.
Your 2 o'clock pretrial.
Yes.
Correct?
If
It's 1 o'clock.
we submitted the original, please confirm that.
I'm sorry?
We submitted the originals, please confirm that. The originals from
Will County.
Will County, that's what you got.
Okay, I mean, I have the originals because they were
Thank you.
sent to me.
Okay.
So, and I'm the one who filed them, so I think I can say that, yes, they're correct.
All right, we'll see you tomorrow.
Thank
Thank you
you.
all. Let's go to the next one.
Thank you.
25 SOEB GP 571.
All right, so.
Oh, it's still there?
Yes, ma'am.
Hang in there.
In this
our
final
money talk.
objection for the day, the objector alleges 5 notarial deficiencies of the circulator affidavits, which objector alleges nullify those petition sheets, reducing the number of valid signatures filed by candidate. These alleged deficiencies are: first, using an abbreviated 2-digit year instead of a full 4-digit year. Second, failure to include a year in the notary date. Third, notary date is unclear, illegible, or ambiguous. Fourth, Illinois is abbreviated within the notarial jurat. And 5, the state of Illinois is omitted from the notarial jurat. So the candidate is represented by Max Solomon. He filed a motion to strike and dismiss, citing the Solomon case. Solomon versus Schofield, SCHOLEFIELD, which is cited on page 406 of your packet. And candidate argued that notarial deficiencies alleged are technical errors that do not warrant striking the nomination papers. The objector in response relies on provisions of the Illinois Notary Act and Illinois Notary Handbook, arguing that complete and unabbreviated information within the notarial jurat prevent ambiguity and require strict compliance. The hearing officer recommends that candidates' motion to strike and dismiss objector's petition be granted based on the following recommended findings. First, that the Illinois Notary Public Act does not specify that the 4-digit year must be included, and using a 2-digit year does not violate the election code or the Notary Act. Second, 2 of the 15 sheets excluded the year of the notarization. 13 of the 15 sheets included the date. And looking at the whole of the petition sheets together, candidate has substantially complied with the election code. Notably, the City of Chicago Electoral Board heard 2 cases, both cited on page 407 of your packets, and determined that the exclusion of the date on the notarial jurat is not a sufficient basis to strike petition sheets. And the names of those 2 Chicago cases are Hendon, Hendon versus Davis, and Ley, Ley versus Williams. Third, the single petition sheet alleged to have an unclear, illegible, or ambiguous notary date does in fact have a discernible date of October 21st, 2025. Moreover, even if unclear, this defect amounts to a technical defect that does not invalidate a petition sheet. The hearing officer cites again to the Chicago Electoral Board's decisions in Hendon and Ley, as well as an additional Chicago Electoral Board decision, Griffin, Griffin versus Hazard, Hazard, all of which are cited on page 207. Fourth, the hearing officer recommends finding that no provision of the election code forbids the use of the IL abbreviation for the state of Illinois, and accordingly, candidate has complied with the election code. Absent actual compliance, though, candidate has substantially complied, as there is no doubt to which state the abbreviations refer. And fifth, the hearing officer recommends that the petition sheets identified by objector as allegedly deficient by reason of omitting Illinois from the jurat are only identified within the recapitulation sheets and therefore do not fully state the nature of the objection as required by section 10-8 of the election code. So as a result of the hearing officer recommendation to strike the objection petition, he recommends that candidate be certified to the ballot. Objector filed 5 exceptions to the hearing officer's recommendation, and in one of those exceptions, objector identified an administrative rule. It's 14 Illinois Administrative Code 176.250, which I reviewed and which does prohibit the use of a 2-digit year abbreviation in the notarial jurat. And objector then requests reversing the whole of the hearing officer's recommendation based on this administrative code provision and deciding the case in objector's favor. So in light of this, I generally agree with the recommendation of the hearing officer to grant candidates motion to strike and dismiss, but for one deviation, and that is to find that the notarial jurats containing a 2-year abbreviation do violate 14 Illinois Administrative Code 176.250, but I recommend that this violation be deemed technical in nature and recommend the board find candidates' relevant petition sheets substantially comply with the provisions of the election code despite the use of the 2-digit year. Accordingly, the hearing officer and I both recommend granting candidates motion to strike and dismiss, striking objectors' objection petition, and certifying the candidate to the March 2026 general primary ballot as a Republican Party candidate for the office of Representative in Congress, the 1st Congressional District. And
Thank
Ms.
you.
King is present.
All right. So Max, no, wait, no, you're the candidate. We'll have the objector first. Ms. King.
And you have 3 minutes.
Yes, 3 minutes.
The Illinois Notary Public
Speak
Act,
up towards that, just
There's
look
that
up
green light.
and so we can hear you, right, hear it all.
the Illinois Notary Public Act of 2023 and its related administrative code, section 176.520 mandate that official notary seals must now show the full 4-digit year, example 2024, for the commission expiration date, replacing order 2-digit year formats with existing seals usable until commission renewal to ease transition. This change, effective with the 2023 law updates, ensures clearer, more complete date information on all official documents, aligning seals with new rules for commissioning and record keeping. The 28 pages cited must be removed as the notaries used 2-digit year in candidates' nomination papers are not according to the Illinois Notary Public Act of 2023 and the Illinois Administrative Code, Title 14, Section 176.520, where the complete 4-digit year mandates be used in notarizing petitions. The board did a count of 775 signatures minus 231 signatures equal 544, too short of 546. The recommendation should be candidate be not placed on ballot. Thank you.
Thank you, Ms. King. Max?
Thank you. Good afternoon, Madam Chair, Board. My name is Max Solomon, SOLOMON, appearing on behalf of the candidate in this matter. Madam Chair, the Supreme Court has spoken. The purpose of notary on a petition sheet is to preserve the integrity. The question is, did this person appear before the notary public and perform that notarial act? That's the purpose of it, to make sure that the election code is not undermined. I agree with General Counsel and the hearing officer that at best, what the objector has argued is a technical default. And the Supreme Court has already said technical defaults or defect does not amount to punishing the candidate and invalidating their nomination papers. On that, I would plead with the board to adopt the recommendation of the General Counsel and that of the hearing officer. Thank you.
Thank you, Mr. Solomon. Question?
I just wanted to clarify what you, a technical defect could possibly not.
I can't hear you.
I was saying a technical defect could possibly not invalid, depends on what that defect is. In this particular instance, we have a standard of substantial compliance, correct?
That's correct.
Okay. And that's where the difference is.
I just wanted to make a rebuttal.
Sure.
Oh, sorry.
So they can hear.
There's no case law about this issue in the Supreme Court or the appellate court.
I just cited my case, Solomon v. Schofield. And before that, there was a case from 1850. I'm not. It's a long-standing tradition for Illinois that technical defects, as far as notarial acts are concerned, will not invalidate the. And I think that case was a mortgage case where somebody was trying to get out of a mortgage because the notary was And the Supreme Court said, no, you're still responsible. But at best, what the objector has argued amounts to technical defects subject to scrutiny or evaluation under the Illinois substantial compliance doctrine. And this, according to general counsel and the hearing officer, suffices under that doctrine.
Springfield, any comments, questions?
No.
I have a motion.
If I could have 2 minutes, Jordan's raised a potential issue to me.
Okay.
Sorry,
Nope.
but I want to get it right.
Yep.
Ms. Martin. Have rebuttal to just.
It's up to the chair. Arguments within the discretion of the chair.
We don't know yet.
All right, there's an issue right now where Jordan is pulling the petition to see where the date was an issue, whether it was in the notarial stamp or in the handwriting. So that's what we're waiting for at this moment.
All right.
Yes, ma'am. May I speak? Rebuttal or wait?
Yeah, well,
Just wait.
before I'll give you. You can sit down. Yeah, relax.
Yeah, you could do it. Either add or not. Yeah. Yeah. Signature. Yeah. We will.
Okay. All right. So sorry about that, everybody. Jordan just caught an important issue, which is the administrative code provision, which is 14 Illinois Administrative Code 176.520, not 250. Only applies to the actual seal itself, and that there cannot be a 2-digit year on the seal. So here Jordan just checked the position, and the seals commission stamp says 04/14/2025. So in fact, that stamp does comply with 14 Illinois Administrative Code 176.520. So my recommendation now is just to follow the recommendation of the hearing officer in its entirety.
Ms. King?
Just wanted to say that
Speak up.
this expands to everything that they do. There is no case law on this issue.
Okay.
So just to clarify, and I want to
It's
say that
also-
just because I am a notary as well, those stamps that we use as a notary are actually manufactured by, you know, the notary, the association, notary association. So if the stamp itself has
2025.
The date of the commission, which was
Right.
04/14/2025.
Right. So if the commission date is correct, the stamp is actually affixed to the document, does not require 2024, does not require 2025.
Correct. It's only if
Okay.
the actual official seal itself says 25, that there is a statutory compliance issue.
All right.
But there's no case law to that. There's no case.
Sure, but the language of the statute is clear.
It's in the statute, which is pretty straight.
Thank you.
All
for
right,
that
do we have a motion?
So moved.
All right, it's been moved
Second,
and seconded to accept the recommendation of the hearing officer
the general.
But
And
that's my modified.
as
recommendation.
modified by the general counsel.
Sir.
All right, Amy, roll call. It's been moved and seconded.
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese. Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right. Nice job, Marnie. Thank you for that. So we're gonna go to 4 and the objections of the candidates that are withdrawn. You need to name them and then we have a motion to that, or do you need to do them separately?
So I will just note for the record that agenda items 4A through 4G, either the candidate withdrew or the objection was withdrawn, and the agenda notices up which one it is. And if we can do a joint motion to dismiss the electoral board cases listed due
On the
to the
agenda?
withdrawal.
As agenda items 4A through G.
Yes.
So moved.
Second. Amy, roll call. It's been moved and seconded.
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese.
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right, thank you. Is there any other business? All right. Comments from the general public. We have people in Springfield.
We have one individual now. He's coming up. Mr. Levitt.
All right, just a second. Marnie, do you have a comment?
Yes, so is it Mr. Levitt or Leavitt?
Levitt, Levitt.
Great, thank you, Mr.
And
Levitt.
Levitt.
So, you certainly have a right to give public comment here today. However, your case is not being heard until tomorrow. So
I understand.
anything you should stay here today is not going to be a part of the record of your case. So if you file an appeal, the board's ruling, everything that you want to say right now is not going to be considered a part of your case.
Not required at all. But what I want to do today, what I want to accomplish today is build some connecting tissue between the case number 538 and cases number 107 and 108 tomorrow that I think is very, very relevant to the decisions that you have made today and potentially might make tomorrow.
I mean, I'm still concerned, sir, that you're creating an opinion on this case before the members of the board in the absence of the candidates, and trying to sway their opinions on your case without the candidates present. So if you want to talk about a case that was ruled upon today, feel free, but we cannot talk about your case until tomorrow.
Oh, absolutely not. There's no discussion being sought today at all. It's just my friend and colleague. He is the person that came down traveling 4 hours with him today. Could not wait for this opportunity to speak. But she also was one of the volunteers, and so I need to speak on their behalf.
All right, 3 minutes.
Okay, it was not my intent when I started this whole objection process to remove anybody from the ballot. But what I've seen today has been very disturbing because I'm seeing how Mr. Fogarty is allowed to, in my cases and cases today, the commonality is that lawyers for the incumbents seem to be given a lot of grace, and they hide behind the statutes. And I heard that come up numerous times today in the petition signature cases, is that the statute binds us to this, the statute binds us to that. And I want to argue the case in 538 today. Your ruling removed somebody from the ballot and has allowed an incumbent who had the privilege of wealth in his family and a lawyer to skate all the way through the November election and into re-election, because politics in rural Illinois is dysfunctional. It doesn't work. There's nobody running for office in rural Illinois counties and sparsely populated counties precisely because of what happens to people who are inexperienced and can't afford lawyers and can't afford days off of work to make an 8-hour round trip down to Springfield or into Chicago. And that's what they did today. And it did them no good because you're all hiding behind the statutes, when what really happened is Josh Atkinson was not removed from the ballot today by statute. He was removed by the ballot by a state board of elections that decided that a technicality, which should have been something a lawyer as professional as Mr. Fogarty would not have allowed to happen. And so he skates through this technicality that says, yeah, well, Mr. Jogerts probably would have hired me anyway, but Mr. Jogerts filed this on behalf of the Republican Party of Illinois, and Mr. Fogarty is always going to stand in and represent them. And so on a technicality like that, Mr. Atkinson is off the ballot and an incumbent goes all the way back into office unchallenged. And I'm struggling to find out how that serves democracy.
I
Thank
think,
you, Mr. Levitt. Thank
Your
you.
argument is with the legislature.
Yes.
Not with us. But thank
No,
you.
it's absolutely with you. Tomorrow, you're going to be asked to rule on cases 107 and 108, which are almost identical to case number 538.
Thank you, Mr.
We
Levitt.
can't
We'll see you
talk about
tomorrow.
your case.
All right.
You can talk about 538. You cannot talk about tomorrow's case.
All
Thank
right.
you.
We are going to recess the State Board of Officers of Electoral Board and reconvene as the State Board of Elections. Is there any other business? Do we have comments from the general public on this part?
Do we need to take a
recess?
Oh, we need a roll call. Amy, sorry about that. We do too
Have a
many.
motion in a second.
We'll have a roll call for reconvening as the State Board of Elections.
Okay, Ms. Ballard-Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese?
Yes.
Ms. McCrory,
yes.
Mr. Frett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turvin,
Yes.
Chair Donahue.
Yes.
Motion passes.
So, other business? No. Comments from the general public? No. So, our next board meeting is scheduled for tomorrow at 8 a.m. January 8th at 9 a.m. And can I have a motion to adjourn? Or do I actually adjourn?
Yes.
Or just?
Yes.
All right. Adjourn. We're adjourned.
All those in favor, say aye.
Aye.
As opposed to say nay. Oh, that motion carries.
Aye.